Yes.
Yes, we have some issues to take up the jury.
You're gonna have to hold this.
A charge, first degree murder, second degree murder, manslaughter, disorderly conduct with a weapon. We've never gone to trial.
Well, I'm fine with that.
Almost 3.5
Yeah,
years.
they say it's too much. But I'm just saying, it's like, because this thing over here, this thing really keeps up.
The paralegal sitting with me is Alessandra Bermudez.
Okay. I wish, well, because like, that's what I'm because they're so worried it's gonna.
Yes, Bermudez.
I wish, but I don't think they will because they were not the lead.
Doesn't matter to me, but.
We can. I should ask. No, that's fine. Let's do that. It's your preference.
I need to talk to you like right
I don't think it's sidetracked on. Okay. This is for the. Thank you. Just make a motion to sever it and have it tried in the other room. I want it.
You say, yeah, I agree.
Hey, Roy.
That jury room looks great. All cleaned up. I'm trying something different. I have coconut milk, like in the can. Huh? It's pretty good. Yeah, I think
Because I'll be going right there.
does it have?
This is my old case, how messed up it was. But this is on my gun rights. It's got pantry next to an old.
Good morning, thank you. Please be seated. So this is day 2 of the trial in State v. Wilson. The attorneys are present, Mr. Wilson is present. Mr. Kimminau had some issues he wanted to present. Before I turn the floor over to him, on your table when you came in this morning, there was a paper with the charges. That is the way the court plans on reading the charges. At the end of the preliminary instructions, a copy of that paper would go in the jury notebooks. They maintain the notebook during the trial with the preliminary instructions, and we kind of add to it, the final instructions later, of course. But if there's any disagreement needed for a change of those, then you need to let the court know very quickly, because my hope is that I will be reading those preliminary instructions well before noon, and we need to make the copies. And of course, I'm sure the attorneys will be ready when I say time for opening statements, particularly the one that goes first, but I'm hoping to start that before noon also, but we'll see. So, bottom line, let me know if you think there needs to be a change to the way those charges are described. And then, Mr. Kimminau, you had some items you wanted to present?
Yes, Your Honor. First of all, since we're on the charges,
I'm going to move to sever the fourth charge and try that with the prohibited possessor charge.
I object to that.
So,
I object to that.
you don't have to be quiet.
Your Honor, I object to that.
All right, so you're asking to sever four and go it over with the prohibited possessor.
Right.
And for the record, number four, of course, count as number four is the disorderly conduct with a weapon at the home of RB on June 22nd, 2017. State's response?
Your Honor, I agree that that's probably a good idea. We're going to need those same witnesses for the disorderly conduct with the weapon to prove that count of the prohibited possessor. And frankly, the homicide charges are so important, I think it would be a good use of this trial to focus on them.
Okay, well, there's no objection. I'm going to sever it. I do have a question, though, to make sure we're all on the same page. Again, my knowledge of what allegedly happened is a lot less than the attorney's. So if I'm mistaken, you'll let me know. But this alleged incident occurred on the same day, and the alleged victim in the homicide was present. There was some type of altercation. Are we going to hear the same evidence, I'm wondering? Even if with severance, we're going to hear the evidence of what the state believes happened, which are the underlying facts behind count 4. Ms. Zucco?
Yes, we'll hear that evidence.
And Mr.
Yeah.
Kimminau acknowledges that?
Yes.
Okay,
Your
just want to
Honor,
make...
Your Honor, I'd like to put forward an affirmative defense on that.
Well, you'll do that in a different trial, Mr. Wilson. You're not going to be speaking hardly at all
Well, I have
because
an
you have a
effective
lawyer.
assistance of counsel, Your Honor, and
Pardon?
he's not putting forward the affirmative defense that I asked him to put forward. There's a broader
Okay, you're
picture.
done talking. Thank you. He's your lawyer. The lawyer decides what
He's ineffective
strategy to
assistance of
present.
counsel, Your
You're
Honor.
done. And I'm not going to ask you to elaborate, but just make sure everybody understands, disorderly conduct will not be decided, that charge, by this jury. So there's no need to present any defense as to the disorderly conduct charge, because
Your Honor, I
the
already
jury
have the
will not be
affirmative
making a
defense.
version of that. And I'm just talking right now, Mr. Wilson, and you're being quiet. Thank you. So it is ordered granting the really stipulation to sever count 4. So this trial will decide just counts 1, 2, and 3. 4, 5, and 6 will be tried separately. We'll worry about that at the end of this trial, and I will make sure that I make that mark on this paper. So that was, I appreciate you bringing that up now. Mr. Kimminau, anything else?
Also on these, I believe that actually, that number 2 and 3 are actually lesser included of number 1. I don't think that when the time comes, they were actually going to give them a separate verdict forms that include counts 2 and 3. That would be totally inconsistent.
And you
So-
may be correct, but I generally would let the jury know, these are the charges now. I've had trials where one of the charges went away during the trial. And we just let the jury know, you're no longer going to be required to make a decision on certain counts, or the form of verdict. Obviously, I've had several trials involving lesser included, and the form of verdict discusses, you know, you know what a form of verdict looks like for
That's
a
why this is
lesser
a flawed
included,
theory.
but it mentions both charges.
Yeah,
both
yeah,
the main
no.
and the lesser.
Right, when they're lesser included, right. But it's different than if you have 3 different counts.
Exactly why this is a
It's,
completely flawed system.
it's clearly different.
Well, you're saying there's something wrong with charging the lesser included?
I don't think it's appropriate to charge them like this, but
Well, let's hear the state's response. And last time she agreed with you, we'll see what she said this time.
Your Honor, the reason that they're charged is because we had a proposed form of indictment for the grand jury, and we
Because you
didn't
withheld evidence.
want to
Mr.
sway.
Wilson, it was so pleasant yesterday.
You were
Frankly,
pleasant yesterday too, Your
the
Honor.
other thing, the only problem we had yesterday, which wasn't a problem, only delay we had yesterday, was the attorneys raising issues, which we dealt with, and that was all fine.
And Your Honor,
So,
you
Mr.
might
Wilson,
ask me why.
you need to be quiet. You're not going to be speaking during this trial.
It's not supposed to be a trial. I have an affirmative defense, Your Honor.
A defense gets presented at trial. As I mentioned to you last time, I'm sure, there's going to be no dismissal
I'm
before
not
this
asking
trial
for
starts.
dismissal. I'm asking for the law to be presented to protect my constitutional Second Amendment, or Article 2 of the Arizona Constitution, and let my attorney put forward the burden of proof. So I can go home, I have an affirmative defense to both situations, the gun rights and the murder. We already know that the prosecutor withheld exculpatory evidence, Your Honor.
Okay, now I'm going to interrupt you. I want to get that on the record, so there would be a record what Ms. Wilson's trying to say, and that clearly involves trial strategy, which is up to your lawyer. I'll warn you again, Mr. Wilson, if you interrupt during with a jury present, they may draw a negative inference. I will not grant a mistrial because you're quiet, please. Quiet. Thank you. They may draw a negative inference against you if you interrupt, particularly if I have to, raise my voice a little bit, and that will not be grounds for mistrial. I'm deciding that right now. So if you wish to be a participant in this trial to the extent and a defendant represented by counsel is allowed to participate, then you're going to need to conform. And if I've made a mistake, then if there's a conviction, there'll be an appeal and some higher court will review it.
So that with you in this court.
We're now done talking, Mr. Wilson. If you interrupt again, I may have you removed. And if you're removed, you won't be coming back today.
Let's do it. I'm gone.
Ms. Wilson, sit still.
Come on, sir.
Ms. Wilson, sit down.
No, let's go.
Sit
No, I
down.
don't want to be part of it. He's ineffective assistance to
Sit
counsel.
down, Mr.
He's
Wilson.
ineffective assistance to counsel, Your Honor.
Thank you, Mr. Wilson, for sitting down. I'm concerned you're making a rash decision. Now, I would be willing, if you convince me that you calmly thought about it, to allow you to waive your presence during this trial. I'm sure your attorney would recommend against that. Correct, Mr. Kimminau?
I would prefer that he be here, yes.
Sure, you prefer to be here. I've been a defense counsel for many, many years. He'd prefer you would be here. But you're not just
Can
going to
you
walk
understand?
out quiet. You're not going to walk out. So I want you to calmly think about it. And what we're going to do is finish what we're doing now. And then, if you want to make a request to waive your presence, we will talk about that calmly, and I will decide. But I have to make a record that you did this knowingly, intelligently, and knowing your attorney's recommending against it, and you didn't just get mad at me for a moment and decide to try to walk out. All right, so we're going to finish what Mr. Kimminau needs to present. Thank you. Mr. Kimminau,
I think we're
and I'm
actually-
sorry we lost track. We're talking about the lesser included, and Ms. Zucco has actually had the floor.
Thank you, Your Honor. Your Honor, the history of this is that we presented all three as counts in a proposed form of indictment so that we would not so that we weren't influencing the grand jurors as to which to choose from, and they indicted on all three. In previous hearings, when previous defense counsel have brought up the issue of multiplicitous indictment or duplicitous indictment, I believe Judge Conlog indicated that because they are lesser included, and I think that counsel agrees with me that these, as they are lesser included of first degree murder.
I agree with that.
So there's a stipulation that jury, if there's evidence presented, that lesser included will be instructed in the jury instruction, and there'll be probably verdict forms with alternatives for lesser included. I believe Judge Conlog previously stated, and may even have even ruled, so it might be law of the case, that he was going to only read first degree murder.
Yeah. And again, I don't mind y'all tell me things because I did not go through and read every page of the court file.
So as
So
long
what you're
as
asking me to
there's
do,
an understanding that they are lesser included, we're fine with just reading first degree murder at the beginning of the trial.
Yeah. I can stipulate that second degree murder and manslaughter are lesser included for first degree murder.
and that's one thing we can all agree on this morning.
Thank you.
I've marked those. Well, now you can read what I have for count one, which is from the indictment, so I assume everybody's good with it. Correct, Mr. Kimminau?
Yes.
Ms. Zucco?
Mm-hmm.
Yes.
And I'm very glad at this point that when I gave the brief description of the charges, I just said, and other charges, and I'm not going to go back and explain that, because I'm not convinced they remember every word that I said. particularly things where I wasn't emphasizing it. So we will just ignore that, and I'll redo this, and it'll just have the very first count on there. All right.
Right.
Thank you. Mr. Kimminau, anything else?
Okay, yes, the next thing, Your Honor, is, do you have the availability to do Zoom, for Zooming here and putting it up here on the screen, do you know?
I'm going to say in theory. This is my IT situation. Probably a month and a half ago, we did test Zoom in the divisions, and it appeared to work. I was absent for that, so I didn't really see it work, but I'm told it worked. A great deal of the hardware in this courtroom was replaced on Friday to correct some problems. I'm sure they tested what I needed tested. I'm sure they didn't test Zoom. So in theory, it should work, but it would not surprise me if I asked the IT person if they said, well, you know, because we changed something, something's got to get redone or whatever. What would you want to do over the Zoom?
Okay, so the reason that I brought it up, and actually I think that both of us potentially have this issue, that I have at least one witness, and by the way, if we can work on it, work an agreement, or if this would be allowed, we have time before we need to do it, so we can find out. We're not going to do it today, obviously.
Yes.
Anyway, there is one witness, Miss Warfield, who apparently is bedridden due to some illness, and I had spoke with counsel about possibly doing a deposition. She agreed to that, but I was wondering it would probably be better if we could set up and possibly arrange for a Zoom. After that, counsel, I think emailed me, I think, or texted me last night indicating that there was one of the criminalists that they're going to call as a witness that's requested to be present by Zoom. And then we also, I was also informed yesterday that the state may not be calling Nico Ochoa. The defense would want to call Nico Ochoa. Apparently one of the reasons why it's a potential problem is because he's in Yuma and he apparently is on probation, and they're having problems transporting him down here and having a place for him to stay. So I just thought, well, possibly that would be another witness. There's been other witnesses who have asked to be present by Zoom. It's certainly not the preference. We have not agreed on anyone yet to be present by Zoom. The one witness that counsel asked me about, the criminalist, I do not believe I'm going to have an objection to that one being present by Zoom. The other ones were like the medical examiner. Well, I did object to that. But all I'm really asking is that if it's something that is available to us, then is it something that perhaps if we agree that we can take advantage of?
So I think what I would need to do is find out before we really make any decisions or make any argument on it. That would, of course, involve someone coming in the courtroom, which might not be available to them till like the end of the day. They came here at 4:30 yesterday to test some things. Stayed late, and I'm sure they could do that today if we could give them that time at the end of the day.
Or even possibly during the lunch hour.
I
guess they get their lunch hour too, though.
They do. And again, it's not like we have a little team of people who are able to do this. And if some other division or other court is like counting on them to fix something for them today. But bottom line is, I'll find out. Okay. I'll talk to the person and see, first of all, what does she think, just off the cuff, about it working, and if she needs to test it. A couple of things. Let's assume that my IT person says there's no problem. This will be the first time I've used it in the courtroom. I'm not a Zoom person at all. And also, while I'm sure a criminologist could get to a computer and would be able to take care of it, I would have some concerns with whoever's going to call a lay witness. So for example, Mr. Ochoa, that everything's going to work fine on their end. I mean, there's obviously inherent problems with relying on perhaps a non-sophisticated person to get their end of the technology working. I just find that out.
Zoom's really easy. It's an app on your computer. You just click on it, downloads it, and certainly those are issues that we could work out ahead of time to make sure that it was working before the witnesses were called.
Okay, all right. Well, I'll inquire. I'll inquire as, we get done with this, I'll go ahead and try to get an email at least, try to call her to, get it started.
Okay.
Yeah.
The next thing, my client is still having problems at the jail with appropriate telephone access. Apparently, they've only been allowing him to use the telephone during his 1 hour time period that he's out or whatever, which is not during normal business hours. My office has taken some of those phone calls, but it has created a problem and continues to create a problem. Now that we're in trial, I need to have phone access with him if he wants to call me, essentially at any reasonable time that we're not in trial.
So that would be in the evening, I suppose.
Yeah, in the evening now, or, keep in mind it could be on weekends, and on Monday it could be, because we're not in trial, at, really any time, probably after, normal business hours into, the evening. And I will say that I have been able to arrange telephone calls when I want to talk to him. My staff has been able to set that up, but he's attempted to contact my office on numerous occasions, my understanding, and he's being severely restricted.
Okay, so the note I made, again, something else I'll have to first check into, is that telephone calls, Mr. Wilson calling his attorney or office evenings and weekends.
Well, and also during normal business hours.
Well, won't y'all be here during normal business hours other than
Not on
Mondays?
Mondays. Yeah, not on Mondays, right.
Okay.
I mean, certainly if he's here, he doesn't need to call me, but.
I forgot Mondays. You're right.
All right, so the next thing is, first of all, there shows that there's a Wi-Fi guest. Is there do we have access to Wi-Fi? Do you know?
Well,
Through a Wi-Fi guest?
Yes,
It has a
you could get-
passcode.
you could have access to that. It's not a great secret. It's on a bulletin board in one of the hallways over toward the jury room.
Okay.
I just thought there the other day.
Okay.
So you want me to get that for you?
No, I'll get it. I don't need it right
Okay.
now. I'll get it.
And again, it's not the best system. I mean, I use it for personal things like reading the news during lunch and things, and it's not the strongest signal, but it's,
All right, well, I have a hotspot here on my phone as well that I use, so we'll do the best. I mean, I'm not heavily reliant upon Wi-Fi. I have everything on disk and things. The next thing is the exhibits. Apparently, you did send out the order, which I saw. I was under a misunderstanding about how this exhibit process was going to work. You sent out an order saying that the exhibits are not going to be distributed, and it has to be shown on the courtroom. I was assuming when you did that, of course I know what assuming does, obviously. I was assuming that you had an overhead projector system so that we would be using the actual exhibit and putting it on something that would then display it. Okay?
Okay.
Apparently, that's not the case. I have no idea how to hook into this system. I looked earlier today, and it doesn't look like there's normal USB ports to hook into. So that's going to be a potential problem here. And I also understand that there's some issues with numbering of exhibits and things of that matter. But if you're expecting us to do this, we're going to have to do something to see if we can get hooked into the system.
well, first, yes, you could get hooked in. When I call the IT person, it's just easier for her to show you rather than, I've never actually done it. I know in theory is I put the monitor on a certain setting and you make a, I don't know if it's Wi-Fi or Bluetooth, connection to the monitor, and then you display what's on your, and again, you have to have a laptop to do this, onto the big monitor. Now, I did that order very quickly, and if there's a problem, because I thought, okay, what if they just cannot do it that way? Or if it's some item that you really can't display that way. My fallback would be, we'll do it the old-fashioned way and pass it around, and we'll just pass the hand sanitizer around with it. And I think that would be okay. So when I put that out, I did it quickly, so I'm not gonna say you're forbidden to ask for it to be passed through the jury. I'd like to try to limit that is probably what the way I should have worked it. But I can't have the IT person talk to you. You don't have a laptop, right?
So I have Mr. Rudroth, I have one here, and
Oh,
Mr.
okay.
Rudroth has one as well.
So if we can do it that way, great, but that would be my fallback, is we just pass it around, and we pass the ball of hand sanitizer along with it, and I would think, if I was involved, I would think, all right, I've cleaned my hands now from what I touched, I'm good to go.
Okay. And then the final thing I had was, my client indicated that, if you recall, I think it was back on around August 5th when we had one of those hearings, that you said to him, "Will provide me some information," or something to that effect. He said that he sent some stuff to your chambers, and he would just wanted to know if you received the stuff that he sent to your chambers.
No, I've not received anything that would have been generated by Mr. Wilson, and since his request for a new attorney, which I set for hearing, and, you know, I'm never going to deny that I said something like that, but I can't imagine what I would wanted to see. I did make a ruling on denying the request for a new attorney and went to some long explanation about that, so I'm not going to reconsider that. But I didn't receive it.
You
is the bottom line.
did not?
Did not receive
Right.
it.
I don't even recall what it was, but he just
I
asked
don't
me
either.
to check.
It could be, whether it's in the file or not, I don't want to go looking for it, but I didn't receive
I
it.
sent it in-house mail from the jail, sir. It was two different issues.
I'm not denying you sent it.
You asked me about it, I sent you the stuff you asked for.
Didn't see it.
I'll ask the jail why it didn't get here then.
So,
Not gonna look at it if it gets here, but go ahead, Mr.
can we approach on one other issue?
Sure. And for the court reporter, if we should test that before we get the jury in, like with no one in,
We have a break over and get the other headphones and I'll test it.
Okay. So if you need me to help test it, like me to flip this on or something, just let me know.
Okay.
And we'll do that before the jury
Okay,
comes.
can you do that too?
I don't know. We'll have to ask Angie if she can do that. If she can touch a button and turn the bench on and off like that.
I can't tell. My phone's not supposed to touch this.
Well, I'll ask her later. All right, so we're back on the record. Mr. Kimminau, was that the items?
Well, let me see if I can think of a few more.
Okay, well, I do want to get started.
Your Honor, there's some confusion.
Hey, hang on one second. The clerk wants to ask me something.
Maria wants everyone to know that Miranda Maya number 22, her last name is actually Pyramid. So I wrote that in for them, so
Okay.
that doesn't throw them off.
Okay. All right, that had to do with the name of a juror, which I won't say out loud, of course, but the clerk's given that to you. I guess we had some error in the person's last name, which of course makes no difference because we use numbers. Ms. Zucco, you need to get near a microphone, of course.
Sure.
Your Honor, is it the court's order that there may be 2 victim representatives in the courtroom during the trial?
Well, let me define that. What I was asked specifically was about the parents. I said the 2 parents can be in, and 1 person from victim assistance may be in with them.
Okay.
But that's what I said. Because there have been requests by many other people to sit in, watch somehow, and of course I'm trying to be even-handed on that, since I'm telling many people no. All right, so I think we're ready to bring in the panel.
Yes, we have a bathroom there.
Well, it'll take some time to get them in here, so you have until they're sitting in here, and then I'll come in and we'll do it just like we did in the afternoon yesterday.
Seat right.
Thank you.
I don't have to listen more. I can give you. I can it's not.
Or you need to change all around?
Yes.
Yes, you did.
I don't have to put under money.
Can I see if nobody can copy real quick, just like.
Well, this has my notes on it too, so.
I can even read the other one.
Allington, here, you just want to jot it down?
If they wrote it, if they pitch, you don't need to see your notes, it's supposed to try it.
No. I'll just jot it down. It's my order. But it's going to be out of order. Because we got things that come down and one coming down. So, ready? Here's what I'm going to do. David? Stevens? No. Okay, can we have this other one? No. But here's the one you need to do. I guess turn on the white ones and then maybe, that'll work better for you? Yes. Or keep pushing. Okay.
I've removed Cheryl.
Here's your, I guess, keep right here.
Oh, yeah, right in the,
Yeah. Yeah, that makes a difference. Okay. Where's your partner? Can we try one more time? Oh, sure.
So, one
Oh, cool. Thank you.
Yeah, it's a good time to walk in. It's such a cute little town. It's just-
Do you know if Lori, do you know if we're ever gonna get a jury list in order?
I would hope so, we would when we get down to the panel.
Yeah, I would hope too.
And they're saying their numbers? Is that how it's-
They're using it by numbers, yeah.
They have a first grade jury last week with numbers.
Oh, okay.
Everybody's a 7.
I heard,
What happened?
All I can say is this.
I don't know anything about this one,
You call. And then Brandon. I can't really see it.
I guess my question would be, why would they suspend it?
We're way sure. Do you? I did yesterday.
You would have paid for it.
All right. Thank you. Please be seated. Hey, the date is September 16, 2020, and this is day 2 of the trial in State v. Wilson. The attorneys are present, Mr. Wilson's are present, and we have groups 1 and 2 of the jury panel present. Thank you for coming back this morning. I want to make sure this is on the record, and in case anyone in group 1 notices, juror number 2 was excused. And I know I forgot to tell the bailiff that, so he was looking for her. And that was a young school teacher who had some work problems being here for 3 weeks. So anyone in group 1's wondering, this is her, that's what happened. In a moment, the attorneys will be allowed to ask you questions. That will start with Ms. Zucco. First though, you will recall I asked you if you knew anyone within your group. We've now combined the 2 groups. So I'd like for you to look around and see if there's anyone you know who is actually in the other group, so you did not realize they were involved in this. And of course, raise your hand if you're a yes. Everybody's looking around. I don't see any yeses. And now, Mr. Kimminau, I'd like for you to introduce Mr. Rothrock, since he's present now. His name was mentioned yesterday that he would be here, but...
Yes, this is Mr. Rothrock.
And sir, if you'd lower your mask, please.
Thank you, Matt.
Let's let him get a good look at you. And you heard his name yesterday, but he may be in and out. I'm not sure if he'll be here for the whole trial. But now that you've seen him, does anybody know Mr. Rothrock? Go ahead, have a seat, sir. I see no yeses. And let me add that if during the trial there's a witness who you realize you know that person, perhaps you didn't recognize the name, or I mispronounced it, or there's just a lot of names, you should immediately put your hand up and let the court know. I'll probably have you come up, but we would take care of that at that time. So, with that, Ms. Zucco.
thank you, Your Honor. Good morning, ladies and gentlemen. Again, my name is Lori Zucco. I am the Chief Criminal Deputy for Cochise County Attorney's Office. And I want to thank you all for yesterday and today, for your time, for your honesty in answering all of the questions, which I know can be personal and I'm going to ask some personal questions, and I really appreciate you participating in the process. You heard what the charge is in this case. It's serious, and so that we appreciate you help us get through this process. I want to begin by saying there were 2 witnesses, they're criminals from Tucson, that were left off the witness list inadvertently yesterday. So I'm just going to tell you their names. If you know them, please raise your hand and we can talk about it. That is Star Douglas and Cindy Star Hickman. Does anybody know those folks? Okay, I don't see any hands. Thank you. So this is a new process for me. Normally we have a seating chart with assigned seating, and we're just starting the numbers system. I would try to remember everybody's last name in the old system, but so let's see if we can just go through it. I wanted to touch on some individual jurors just to do some follow-up on questions that you answered yesterday. So do we have juror number 25? Sir, if you're comfortable lowering your mask to answer, I think the court reporter would appreciate it. Thank you. Sir, I just had some follow-up questions. You said that you were on a jury trial before, is that right?
That's correct.
Was that here in this courtroom?
It was in Idaho, way down.
And how long ago was that?
12 years ago.
Okay, were you the foreperson?
No.
Do you remember what the charges are?
It was a drug case that he was supposed to have a large amount of drugs in his house.
Okay, do you remember what the verdict was?
He was guilty.
Do you remember about how long that trial lasted?
It was 3 days.
Okay, this trial's scheduled to be significantly longer. All right, and was there anything about that experience that that you either enjoyed or didn't enjoy?
Well, I enjoyed seeing the process of what was going on, but I thought we took way too long.
You mean the pace of the lawyers?
Yes, they were.
Not the deliberation?
No, no.
Okay. All right. Thank you, sir. I appreciate your answer. And these questions are mostly about prior jury experience. It's an interesting thing for us to know and learn from jurors who have participated in this same process in the past. So, juror number 33? Oh, yes. Hey, ma'am, good morning. You talked about some prior service that you did in Los Angeles, is that correct?
No, both one in Tucson and one in Houston.
Okay, then I got that wrong. Did you live in Los Angeles before? Okay. There's my note taking. Can you tell us about, let's talk about the first time you were a juror.
The first time I was a juror, I was on a case that involved narcotics, cocaine, and the client was found guilty. He had the cocaine in possession, but insisted it wasn't his.
Okay.
It was caught with it in possession. He was found guilty.
How long ago was that?
Both of these cases were back in the 80s.
Okay.
And then the other one was a stabbing. The gentleman was at a party. He admitted to stabbing someone, but his defense was, I was drunk, so how did I know it was him?
Okay. And what was the verdict on that one? Were you the foreman in either one of those? Okay. And was there anything about the process in either time that you remember that sticks out in your head as either positive or negative?
No, it was just something that I enjoyed watching the process and being involved in everything as it went along to go through the steps and learn what constituted guilt or innocence.
Okay. Well, thank you. Thank you for sharing, and thank you for your prior jury service. As my detective just pointed out, it was juror number 34 who was a juror in Los Angeles, correct?
No, 35.
35?
That's me.
All right, my numbers are wrong. Can you tell us, all right, what is your juror number?
4.
Okay, you are juror 34.
Oh, yeah. I shouldn't be on this jury.
Okay, you are juror 34.
Yeah, I'm
Okay, and you have prior jury duty.
in Los Angeles, yes. Where I've lived my whole life until
Oh, how long have you lived in our community?
about 12 years I lived in Cochise.
Okay, that's a pretty long time. It's about how long I've been here.
Yeah.
Okay, so tell us about your jury service in Los Angeles.
The first one was a gentleman who was on trial for robbing, and we found him not guilty because we didn't feel there was enough evidence. Somebody identified, they said that the guy was walking down the street, and we felt that wasn't, because he wasn't doing, anyways, we found him not guilty. And I did forget, I did have another trial with this elderly lady, little tiny lady, who had stolen something from a store. She was kind of homeless. So we found her guilty, but we did tell the judge that we thought he was lenient. I don't know if that counts, but that's what we did. And then also I was on a civil trial, which had to do with real estate. And we found on most of the charge that we did give some money to the person. So, you know, there were several, the whole list of these.
You actually went to verdict, it didn't settle mid-trial.
Okay. We went to verdict. Yeah, in Los Angeles, what you do is, like, we had the first trial, then you sit there for another whenever, and they call you for the next one, because they're desperate. We're at that time desperate. So, yeah. So you didn't go home the next day.
Gotcha. So in the first trial, was identity the issue? Whether or not they had the right person? And that was the not guilty?
Yes.
Okay. And then you were sympathetic to the second person, but you still found her guilty?
Yeah, the whole group, I mean, we as a group were.
Right. Because you were willing to follow the law, even
Yes, that
though...
was the law, that we could see clearly that she was guilty, but, you know,
Right. So was there anything about, same question I've been asking, positive or negative, that sticks out in your mind about those experiences?
No, it was, the trials were, and of course, there's a lot of time where you're down, as you know, as a juror. But, yeah, it was, you know, you just have to keep your wits about you and try to take everything in that you can so that you can get a fair verdict.
Right. Okay, well, thank you. Thank you for sharing with the other members of the jury, especially the members who maybe have not had jury service before. Let's see. There was one other juror, number 35, who's had experience with the court system. Is he here? Okay, and your experience was a little bit different. You testified.
Correct.
And what was that, what was the case about?
It was against the employer attacking the employee who supported the local union. So I was a witness for the case.
On which side?
I was for the union side.
Okay.
Witness, that they called, because I heard comments made by management of the employer that was attacking towards one of the employees. So I went on my side of what I heard, and what comments were made about it.
About how the person suing might have been biased or something like that?
The person that was suing the employer said that they had attacked him and falsely fired him for not practices, for past practices that were done okay, and all of a sudden they weren't, they fired him because he was supportive of me.
Gotcha. And was that during your employment at SSBEC? And was that the employer?
The employer is SSBC, correct.
Okay. Let me ask you this. Was there a process where you were disclosed as a witness and then maybe you did a pretrial deposition or something like that?
Correct. One of the lawyers that called me and asked me a bunch of questions, and we met and we went over the questions that could be asked by some of the lawyers, by the judge, and he just wanted me to give truthful answers of what I knew, what I had told and heard. And so we went over it up until the court date, and then I was called in for a witness, and was there about 10 minutes. It wasn't, I was expecting to be there for a while, but there was only a few questions asked, and I was done.
Did the other side's lawyer talk to you before you testified?
No, not the employer's lawyer. It was union lawyer.
Okay.
I believe correctly, if I remember correctly, it was the union's lawyer.
Okay. And the lawyer told you to just tell the truth?
Correct.
And before you testified, did you have to wait in the lobby for a while?
Yeah, waited there probably an hour and a half.
And how did it make you feel having to get up on the witness stand in front of a bunch of people and answer questions?
A little nervous. First time, anything that wasn't expecting, didn't know what to expect, so.
Right, a little nerve-wracking?
Right, correct. Didn't know, we went over a bunch of questions and I assumed that they were going to ask all those questions, but it was kind of short.
Sure. So even though you were prepared and you had a minor role, you were still nervous having to testify?
Correct.
Okay. Thank you for sharing that. I just kind of wanted to illustrate that you're probably going to see that in this case, even with firefighters or even sheriff's deputies, even doctors. You know, there's a certain amount of anxiety that goes on. So thank you for sharing that, sir. I have some just general questions too. You're going to hear that several of the parties and witnesses involved in this case have struggled or were struggling with drug addiction, alcohol addiction, substance abuse addiction in general. And so I just wanted to see if there's any jurors who have had somebody in their life with a substance abuse addiction where it's impacted them, and that, you know, feelings might come up during the trial, or if you would want to share that experience with us. So is there anybody here who's really, or whose life is really affected by a loved one having a substance abuse addiction? Sir, number?
Number 13.
Number 13. Okay. Can you tell us a little bit?
In fact, when I was a young kid, I was 13 years old. I had two family members who were involved with drug addiction. The main problem that I have with it is we have very spend time in it. Very emotional, let's say. I don't want to say what kind of family member, he was a family member, and he took me to the area, so I could see what everybody goes through.
I'm sorry, what everybody goes through.
With an addiction issue, it's pretty much drug addicts. Some of them were, as you understand, to go through a lot of younger addicts. That's probably the straight line I crossed.
Oh, that's good for you. And your relative that had the drug addiction, what happened to them?
One of them passed away. We ended up with HIV. And the other one, she made it through.
I didn't hear the last part, she made it through?
She made it through and she died in a natural hospital.
Okay, so she eventually recovered and had a normal life?
Yes.
All right. Do you know about how old was she when she had the addiction?
I was about 13, so she was probably about 24. The other one was about 17.
Okay. And he developed HIV? All right. Well, thank you, sir. But is there anything about, this trial you think you're going to be okay sitting on this?
Yes, I'll be okay with it because through the years I have learned more about addiction and everything else. Myself, always what they've been doing.
Sure.
I had
And I had
I had help other people in the community also.
you need to keep your voice up, please.
I'm sorry,
Okay. Thank you, sir. Thank you for sharing. Another name, ma'am?
My number 3.
Okay.
I have a brother that's 4 years younger than me, and he's been doing drugs off and on since he was probably 16, and he's now 60, and he's been in and out of prison, and so I haven't really had much to do with him. I mean, he's been confined.
So, and no, I did not write him, I did not do the things that he thinks his sister should have done, but,
And he's never recovered from it.
he is now.
He's no longer an addict.
Right.
Do you know how long he's had sobriety or clean?
I think it's only been like a year so far,
Okay.
so it's, you know.
You're not trusting it yet? Gotcha. All right, is there anything about that sort of lifelong struggle you had with your brother that you think might bring up emotions for you here in testimony about drugs in this case?
No.
Okay. All right, thank you. Thank you for sharing. Ms. Ham?
I was 34, not at this time. My son was an alcoholic. He started when he was a teenager. He's never been arrested though. And he did quit drinking about 10 years ago. He's been going to AA since, and so I consider him.
Sure, 10 years, that's a long time.
Yes, yes.
How old is he now?
50. He might be that old, maybe that old. He's 54.
Okay, 10 years, so congratulations to your son. Thank you.
Thank you.
Thank you for sharing. Anyone else? Anyone else? Okay. I'm going to ask you a question, and it's a little bit unusual, but I hope that you would be honest. Is there anyone here who has ever been in a fist fight? Okay, let's start with you, sir, because you haven't said anything yet. Juror number.
32, growing up in the playground.
Over how many?
35 years.
Okay.
Nothing significant, just being hit.
All right. And what about, around what age are you talking about?
12, 11, 12, 12.
Okay. All right. Were you a participant?
Sometimes.
Yeah. Did you ever get injuries?
No.
No. What about the other people?
No.
Okay. All right. Thank you, sir. Thank you for sharing.
Number 25.
Okay.
I was in high school, and one of the guys just come up and he says, well, I'm just at the beach club. Okay, let's see. And so he did.
He did it?
That was his end. So.
Oh, did you exchange blows?
Oh, yes, we had a knockout.
All right. And did anybody have any injuries?
No.
Nothing serious?
Nothing serious, other than knocked out.
Okay. Is there anybody else who's been in a fight as maybe a young adult or a college age? No. How about witness a fight of people in young adulthood? Sir?
I said I did 30 years, I'm 13. I said I did 30 years in the Army, and I also ruled at I see the fight. I see the friends of mine. I see that at home when I was growing up in high school and schools. I was one of the guys that beat up on the boys in high school. We played basketball, and it was always that particular person. Injuries, I ended up with a couple back guys, broken legs. Like I said, my life was completely different.
Okay.
Military, that's all we see around. How you just go boxing, you get anger,
I'm sorry, the anger and.
you get it out of your system, the anger.
Okay, so in the military, sometimes fights will just break out to sort of let loose.
That's correct, yes.
And what kind of injuries would come from
Just
this?
minor. I'm somebody getting a broken leg or cut eye or black eye.
Bloody nose?
Yeah, a couple of knuckles.
I'm sorry, yeah, a couple of.
Knuckles. Other than that, that's about it.
Ever seen one or been in one where the police got involved?
And peace, yes. See that in the club, from a distance, I wasn't part of it.
Right. Okay, and were those ones where there was more serious injuries, or?
No, not really, they just more people involved, that's all.
Like a bar brawl?
Pretty much, yes.
Okay. And is that pretty regular in the military?
Yes. We live in the clubs and parking lots, out in the fields, most of it in the service, you guys know how it goes. So those are the ones that we tell, we don't tell.
Gotcha. All right, thank you for sharing. Were you nodding your head, sir?
I was just kind of laughing. About situation.
Number?
Number one,
Okay.
I got a boxer's break when I was a sophomore at school. Guy a year older in school decided that he didn't like me at the bus stop, started hitting me, and I started hitting back and broke my hand. But that was it. I mean, that was September 11th, 9/11. I turned 59, and that was back when I was in 9th grade.
Were you in the military too, sir?
No, just a military contractor.
Oh, okay.
Yeah, I only been back in the States about a year and a half. I contracted in South Korea for 5 years, in Afghanistan for almost 2 years. And I've just been back in service there in about a year and a half.
Okay. All right. Did your hand heal up?
Oh, yeah.
Did the other guy have any injuries?
Well, we both had bumps, but it was settled after that.
All right. Thank you. Is there anybody else over here? Can I raise hand? Anybody? All right. Let me ask you this: has anyone ever been in a situation where a firearm was like pulled by somebody, or used by somebody, or brandished by somebody? I'm sorry?
You're talking like in a.
I can't hear you.
I'm number 22. You're talking about like in a hostile kind of situation, or just in general because a lot of us are around firearms.
Oh, well, I'm not talking about being at the range. I'm talking about where it's maybe a spontaneous situation.
Okay. No.
No. Were you going to answer that you've been around firearms a lot?
Well, that's why I wanted clarification on what your question was actually trying to get at.
Okay, well, I haven't talked to you yet, so you can tell me about that. Number 22. Are you familiar with firearms?
Yes.
Okay, and is that I know your brother-in-law is with the sheriff's
My
department?
brother-in-law is the sheriff's department. My family has a long history of hunting, military service. Obviously, our guns, so we have self-defense guns. So we've been around firearms.
And are you trained to handle a gun and gun safety and everything?
I've had gun safety, yes. I don't have a permit, like a concealed carry permit, since Arizona is not open carry. So we used to have firearms.
Okay. And what are some of the things that you learn about firearms and self-defense?
I'm going to object. I don't think that's appropriate.
I'm sorry, Mr. Kimminau, I need you to speak louder.
I'm going to object. I don't think that's appropriate before the guard.
What was the question?
What are some things that you've learned about firearms and self-defense?
Well, I'm sustained that. I mean, that goes, it's a little too open-ended is my
Okay.
concern.
That's fine. Okay. All right. Thank you for sharing. Is there anyone else who has ever been in a situation? Yes, sir?
31. If you count military service, I'd avoid that act, so I've seen firearms used in different situations.
Okay. I don't want to bring up any specifics necessarily, but can you tell us what happens to a situation when a firearm is entered into, like comes into play?
Sustained. His experience is, hold it, sir. And I know I haven't explained this yet. If I sustain an objection to a question, that means the person's not allowed to answer it. And the reason I'm sustaining it is his experience was in a war zone, and we're not going to have, our incident, alleged charge wasn't a war zone, of course. So I'm concerned it is unnecessary, may confuse the matter.
Okay,
Thank
fair
you,
enough,
Mr.
Your Honor. Thank you. But you've never been in a situation where a firearm was pulled outside of a war zone or the military? Thank you. Is there anybody else who's been in a situation where a firearm was brandished or pulled or threatened? No? Okay. And just a show of hands, because I think we've probably touched on this, and Arizona is open carry. Are a lot of you, raise your hand if you are fairly familiar with firearms or being around firearms? Okay, I see 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, so it seems like more than half of you. Thank you. Is there any one here who's not comfortable or familiar with being around firearms, or who's sort of anti-gun? No. Kind of what I would, oh, sir?
16. I'm not anti-gun, I just don't have a need for it in my life. I stay away from them. I go to a program and stuff.
I'm sorry, I missed after,
Oh,
I
sorry.
stayed away from
I
them.
have no need for them. I don't have them in my life, I don't care for them. I kill my own. I don't need, whatever defense I have my own self. That's it.
Okay, you feel like you can do your own self-defense without a firearm?
And if they have the upper hand, I
I
don't
didn't
believe
hear
in
after
it.
yes.
If they have
Sir,
the upper hand, that's okay, I can do.
I can't hear you, sir.
if you would please lower your mask and slow it down a notch, that'll help her.
I'm sorry. See, the question was if I'm pro-gun, or do I have a gun, or do I believe in guns? No. Okay.
Thank you for sharing that, sir. Is there anybody else who feels similar to this juror? Okay. Let me ask you this. Our justification in Arizona, what we think of as self-defense, is based upon a standard of reasonableness. And so that's a word that's going to come up a lot in this case. And actually, I'm not going to ask a question about it. I'm just going to ask you to keep that word in mind, reasonableness. And that's all the questions that I have for you, ladies and gentlemen. And I look forward to presenting my case to you, and I appreciate your candor and your answers and talking with me this morning. I do. Thank you.
Oh, thank you, ma'am. Mr. Kimminau?
Thank you, Your Honor. Good morning, ladies and gentlemen. Thanks for coming back today. I understand one of us hit a deer or something. One of you all hit a deer or something. We didn't go able to make it back today.
I didn't hear the last part, I'm sorry.
And wasn't able to make it back today.
Thank you.
So the first question I have, and interesting, I asked the other group, nobody answered positive, but a couple of people have already said, yeah, I enjoyed the experience of being a juror, and I'm sure they like it. So my first question is anyone here want to sit on this jury? Do they want the experience? Because they've never experienced sitting on a jury, and it's not something that you have the opportunity to do very often, and probably sometimes in your lifetime. Okay, ma'am, what's your number?
3.
Number 3. Okay, thank you very much. Anyone else?
Sir, yep, never mind, you have several.
Okay.
To your left,
I'm sorry?
to your left, you have some responses.
Okay. And what's your number, ma'am? 33. Anyone else over here? Okay, 30. Anyone else? Next number? 23. So you're making up for the last group, see? They wouldn't believe me that I had people answer this question truthfully. So yeah, they wanted to. And
16.
16. All right. Number 35. All right. 31. 31. 29. And 32. Anyone else? All right. Number 1.
I already gave you my number.
You already did? You know, at an auction, you could get double hit for that. Okay. So in Arizona, council had mentioned justification. This case will not be a whodunit case, it won't be a misidentification case. There's no question that Mr. Wilson pulled the trigger for firearm. The shotgun and the shot hit Mr. Arbizu, deceased, and those wounds resulted in his death. So that's not going to be an issue that you're going to be deciding. The issue that you have to decide is whether or not it was justified. In Arizona, the law says that if there's evidence of justification, that the state's burden to prove beyond a reasonable doubt that it was not justified. It's not the defendant's burden. It's the state's burden to prove that it was not. Does anyone have a problem with that? Does anyone believe that the defendant should have to prove that it was justified? I see no hands. Does anyone have the problem with the idea of justification? In a certain situation that unfortunately a life was taken, but that it could be justified. And that a jury can say, we find someone not guilty because we find it was justified. Or that the state has not proved that it was not justified beyond a reasonable doubt. Does anyone have a problem with that concept? All right. Council, ask you a couple questions about guns. Is anyone here a member of an organization that actively supports gun control or restricting guns? Any kind of legislation or any kind of demonstrations, anything of that nature? Anyone part of any organizations? Okay. In a criminal case, the defendant has the right to testify if he so chooses, and he has the right not to testify if he so chooses. The judge will instruct you that if Mr. Wilson decides that he is not going to testify, that he chooses not to testify, that you cannot consider that in any way in your deliberations. Does anyone have a problem with that? Does anyone think that in a case like this, or any criminal case, that a defendant should take a witness stand and give his side of the story? Or say, why you should find me not guilty? Does anyone believe that they could not follow that instruction? And the judge says, you're not to consider it in any way. It's not to be talked about, it's not to be thought about in any way, shape, or form. Right? Now, the opposite of that is, the defendant can also testify, so Mr. Wilson could testify in this case. And if he does testify in this case, the judge is going to tell you that you are to judge his testimony like you would any other witness. Just like a police officer, just like a civilian witness. You're going to be treated exactly the same. You're not to be any more believable or any less believable just because he sits in this chair accused of something. Does anybody have a problem with that? Does anybody ever think that he's going to have to do something more, be more convincing? I'm going to treat him differently. Does anyone have a problem with the idea that no, to be treated exactly the same, and you can treat him exactly the same if you left on this jury? Okay. Is there anything just about the way that Mr. Wilson looks, that I look, Mr. Rothbard looks, anything about what we look, we're done, any mannerisms whatsoever? You might think it's strange I ask this question, I get people that answer this question. Yes, it is. There's just something about it. But there's just something that you get this feeling or something you don't like. And you say, you know what? Sometimes maybe you have a premonition, whatever it may be, something that's uneasy, that you don't feel comfortable sitting on this jury. Does anyone here feel that if they were in Mr. Wilson's chair and you with your, whatever it is, maybe a question that wasn't asked, maybe we can't ask a question that would prompt the answer, but there's just something about it, you say, you know what, I don't feel comfortable sitting in judgment.
in this particular case or in any case. Did anybody, just for whatever reason, maybe we haven't asked a question, whatever, but we did ask a question, you know what, maybe I'm not the right person for this jury. That's okay, if you do. Maybe I'm not the right person for this jury. Anyone feel it? You and I have no individual questions.
Thank you, sir. Could the attorneys please approach? Okay, ladies and gentlemen, that concludes the questioning. So you and the ones from the other two groups have all been found to be qualified, but as has been mentioned, we only need 14. Now, I hope it's obvious why we had to have extra people, because there are some who failed to appear, unfortunately, maybe they moved or whatever, and we never know how many they're going to be excused. There was this traffic accident where one person was not able to make it back. So we need more people to choose from, and I appreciate you being involved in this. What's going to happen next is you'll be excused by the bailiff. We'll go through the final process to select the 14, and they will be called in. And I wish I could tell this to the other group, but I'm trying to keep you spread out. I'm going to thank you, those of you who are not selected now, but you'll just be excused by the bailiff from the waiting areas, rather than bring everybody in here for me to thank them, and let's fill the room up for that, all right? All right, so I'll now excuse groups 1 and 2, please. Go up to the bailiff.
We're asking if they're done for the day, so say we're bailiff for the
Hey, thank you. Be seated. No potential juror is present. Attorneys and Mr. Wilson are present. And let me just talk sort of off the record to courtroom clerk for a moment. So the list of these.
That's all she's doing. She just doing tasks and, 4 years. So she didn't want to come. That's all she can do. I can't believe that I said she said that was before he was told that this is your
so that and you don't have a list.
Because I found the phone. Yeah, they should be like reading by exhibit.
All right, let's go back on the record, please.
Okay, we'll take a look.
So, back on the record, I don't recall this problem in my last jury trial where we used numbers. It was earlier this year. But I need to see if the jury commissioner can generate a list that's by number. And not badge number, which I'm not sure what that even means anymore, but the number we've been referring to them by. What I have right now is 2 pages that have the names of the people who have not been excused, but it would be awkward to use this. I mean, I could go through and I could mark out, put a line through each name whose number falls above the first 26, but it would be awkward then for y'all to, one's left is ones you make your strikes from. So I'm hoping we don't have to do that. I'm hoping the jury commissioner can generate a number, unless it's going to be 1 and then 3 perhaps and 7 or whatever we have left. But I need to ask, and we didn't have this issue last time. So I'll just ask that question, hopefully right away, and let the attorneys know that a list is big on the way, or if we have to do it the awkward way. I mean, it'd be doable. It'd be doable, but I think it would be inefficient. So let's see what we can get. I'm not going to, I don't want to be the one really to raise it, but I did say, Mr. Wilson, we'll get back to him. And Mr. Wilson, I'm sure hoping you're wanting to be here and be in your trial, because otherwise it's going to be at your disadvantage. So I'm hoping that your earlier request to excuse yourself was perhaps not well thought out, and we're going to have you here for the trial, correct?
Your Honor, I would like to be here, but, I do have some issues that need to be addressed. Part of the biggest problem is the lack of communication between me and my attorney. We can't figure out an agenda for the defense, and we can't come to an agreement on some things. There's a lot of things I need to discuss with him.
I understand that,
communications is
keep in mind, someone telling you no is not a communication problem. I am communicating with you, I'm telling you no, that's not a communication problem. Trial strategy, I've made the decision more than once, is up to the defense counsel. With a few exceptions which don't apply here, because he clearly has a defense in mind he's going to present for you. So the defense he presents, how he presents that defense is trial strategy. That is in his hands by law. And again, if I made a mistake and there's a conviction, you can have it reviewed, but that's not a communication problem. So we're going to have you here. We're not going to have more conversations, because certainly not going to try to give you a new attorney in the middle of the trial. But I heard you say you wanted to be here, and I appreciate that. And I know that you can comport yourself, because you've done it every time we've had the jury present, and I appreciate that. All right? So I'll find out about the list. We're on the break. Come on.
He's right. Making a bad decision, Judge.
I have now stopped the white noise that was on to afford a greater degree of privacy to defense counsel and Mr. Wilson. Both attorneys are present. Mr. Wilson's present. And I want to put on the record just kind of quickly the way the strikes were conducted. The jury commissioner created a list for us of potential jurors in the order of the number by which they will be referred to during the trial. The delay was because I'm apparently the only judge who's done a trial this year, since we started using numbers, who thinks this is the way to do it. So that's why they were not expecting the request. Sorry for that delay. So there were 2 on the list, though, that actually had been excused, and the jury commissioner didn't know about that. That's jurors number 2 and 10. So I drew lines through their names and put my initials by it, Numerous was passed back and forth between prosecutor and defense counsel, each drawing lines, putting their initials, either LZ or CJK, and that's how the jury was selected. So that will become part of the record. And since I've not said this, like courtroom on the record, it is ordered that any document that has the actual name of a member of the jury panel or a person who's actually seated as a juror is sealed until further order of the court, meaning not available to the public. And that means, of course, the participants are ordered not to provide those names to anyone. And I think, I want to give you an update regarding Zoom. Yes, it should work, but wants to double check. So maybe 4:30 today, we get done and the IT person can come in and make sure Zoom works, and then I need a lesson. Regarding telephone calls, and my assistant's been doing this, so she's going to have to call back for some of these things. Mr. Wilson has an hour, which would be at least in the evening. I'm not sure about weekend Mondays, but at least in the evenings, when he can make phone call. It sounds like it's a designated hour. And I said, well, if we're going to have a designated hour, then defense counsel needs to know what's that hour for Thursday evening, so he can make himself available, which means, of course, my assistant has to call the jail back and ask that. So, let's see. Oh, and with Mr. Kimminau and connecting to the monitors, yes, I got new, she'll help train you, 15 minutes to a half hour. She needs to be told when. So we'll sort of play that by ear and see. I don't see it happening this morning, but it's doable, obviously, all right? So that was the things that I said I would check into. So I believe we are now ready to bring in the actual jury. The attorneys and Mr. Wilson may have noticed the notebooks being passed out. I asked that they be seated in the box and to my left to give the jury the best view possible of the witness stand, as opposed to using my far right-hand side of the spectator area. And I'm going to tell them that's their seat. They always go back there, and the bailiff is going to put them in the same order we have them on the list, so that number one will be sitting, the first one sitting down. So I think we're ready to bring them in, and then I will go straight to the preliminary instructions. Ms. Zucco, anything before I do that?
No, Your Honor. Are we going to break for lunch then, and then come back, maybe even if we have to come back a little bit early to do openings, because I don't want to...
Well, you're not getting opening done today, you know. I can't read preliminary instructions that fast.
That's what I was just confirmed.
This is the exact same thing I had in my last trial, day and a half to select a jury, and I read as far as I can, and then I go to the admonition. Okay. I do it out of order, probably, and then finish the preliminary after lunch. And I really don't like to cut lunches short before 1:30. I'm not sure 15 minutes makes a big difference. Mr. Kimminau, anything before I have the jury brought in?
No, Your Honor.
Thank you, sir. I'm going to remain here, and if y'all have a list, and if you could bring them in, please. You can look up the market, you can look up the market. And always have money, I'll have money. Obviously, you have one. Please be seated. Ladies and gentlemen, you were selected to serve on the jury. I'm going to do just a very quick roll call, using, of course, your number. If you could just say here or yes to indicate you're present.
Get your mask off, please.
Is that better? Is that better?
Yes, sir.
Okay, we can do that. So, like I said, you were selected to serve on the jury. And I'm going to do a quick roll call, using, of course, your number, which is the way you'll be referred to during the trial. And that way the attorneys can verify they know where each person's sitting. We'll know we have the right group in here. This is, by the way, your assigned seat for the trial. So, again, just say here or some yes or whatever. Number 1? Here. 4?
Here.
5?
Here.
7?
Here.
13?
Here.
14?
Here.
31?
Here.
32?
Here.
34?
Here.
35?
Here.
38? 39?
Here.
44?
Here.
45?
Here.
Is there anyone present whose number I did not call? Very good. Thank you. Oh,
I'm not sure, but I think the sequence might be a little off.
well, I mean, we have numbers missing, so it's not a perfect sequence.
In the seating chart, that's what I'm saying, after her, what's the number now?
34.
And then 34, what number do you meant for that?
After 34 is 35.
35?
35.
You're 35?
38.
Oh, you're 38, so then you're 35, so.
All right, so for the record, we're switching some people around, and that's all to try to help the attorneys and the court if I need to try to refer to a person.
Take a look. Take a look.
Yeah, the books are all the same, so it doesn't matter if you take it or leave it, just don't have two. All right, thank you. So now, if you will please stand and you'll be sworn.
Do you swear or affirm that you will give careful attention to the proceedings, follow the court's instructions, including the admonition, and render a verdict in accordance with the law and evidence presented to you, so help you God, or so you do affirm?
I do.
Please be seated. The clerk will now read the charge alleged by the state.
Omitting the formal parts, the grand jurors of the county of Cochise, in the name of the state of Arizona and by its authority, accuse Roger Elaine Wilson and charge that in Cochise County, count 1, on or about June 22nd, 2017, Roger Elaine Wilson committed first-degree murder by intending or knowing that his conduct will cause the death of J.D.A. with premeditation in violation of Arizona law. Dated this 15th day of February 2018, Cochise County Attorney Lori A. Zucco, Deputy County Attorney True Bill, foreman of the grand jury, to which, ladies and gentlemen, the defendant has entered a plea of not guilty, and this is the issue you are to try.
Thank you. I will briefly tell you about your duties as jurors and give you some instructions. At the end of the trial, I'll give you more detailed instructions, and those instructions will control your deliberations. You each have a notebook, and you have a copy of what I'm reading from in that notebook. You are welcome to follow along if you wish to do so. These preliminary instructions are for your use during the trial and to help you better understand the proceedings and are not intended at all to be inclusive. They highlight some principles of law and some rules and procedures about trials and your work as jurors. It is the jury's function to determine the facts. The facts mean what actually happened. You must determine the facts only from the evidence produced in court. You must not speculate or guess about any fact. You must not be influenced by sympathy or prejudice. You will hear evidence, decide the facts, and then apply those facts to the law I will give you. That is how you reach your verdict. In doing so, you must follow the law whether you agree with it or not. You must not take anything I may say or do during the trial as indicating any opinion I may have about the facts. You and you alone are the judges of the facts. Jury service is an important part of our system of justice. It's a long and distinguished tradition in American law. From the beginning, American law has viewed the jury system as an effective means of drawing on the collective wisdom, experience, and fact-finding abilities of persons such as yourselves. While it may be an occasional inconvenience, or worse, jury service is an important responsibility for you, one which I'm sure you will take seriously. At the end of the trial, you'll have to make your decision based on what you recall of the evidence. You will not be given a written transcript of any testimony. You should pay close attention to the testimony as it is given. You've been provided with notepads and pencils, and those are in your notebook. I encourage you to take notes during the trial if you wish to do so. If you do take notes, please keep them to yourselves until you and your fellow jurors go to the jury room to decide the case. Do not let note-taking distract you so that you miss hearing or seeing other evidence. When you leave the jury box for a recess, leave your notes, your whole notebook, on your seats with the books closed. Whether you take notes or not, you should rely upon your own memory of what was said and not be overly influenced by the notes of other jurors. After you render your verdict, the bailiff will collect your notes and destroy them. Do not be influenced at all by my note-taking. What I write down may have nothing to do with what you are concerned with at the trial. I'll add to that I may occasionally be looking at my computer. Again, I hope it does not distract you. Don't pay any attention to it. It has nothing to do with your responsibilities as a juror. And again, going off script a little bit, and speaking of distractions, the court is allowing certain individuals to listen to the trial by telephone. When the white noise is on, when people are called up to the bench, they cannot hear that. Unfortunately, when the people call in and when they leave, it sometimes makes a tone, a beep. And I've noticed some in the jury panel kind of look up toward me. It comes from my direction. So I hope that's not distracting, but that's what it is. I thought, in case you're curious. And some of you have heard me remind people on the phone to mute their phone. I do that if we hear rustling and background noise, which could occur if their phone is not on mute. There may or may not be news media coverage of the trial. What the news media covers is up to them. If there is media coverage, you must avoid it during the trial. If you do encounter something about this case in the news media during the trial, in your exposure to it immediately, report to me as soon as you can. And some of these rules, the instructions are written pre-virus. There'll be no cameras in the courtroom, so you don't have to worry about that. And so no one will be photographed or televised due to the restrictions on people who are allowed to attend in person. During the trial, you may have questions for a witness or for me. Please use the form in the front pocket of your notebook to ask a question. And if you're missing any of these items, please put your hand up and we'll get it fixed. I believe the notebooks are all in order, but we could have missed something. Write your question on the form, but do not sign it, or do not put your number on it. Fold it in half, pass it to the juror in the front row furthest from the bench. The juror will collect the questions and ask the witness, and before the witness is dismissed from the stand, hand the questions to the bailiff who will give them to me. The lawyers and I will discuss the question. The rules of evidence or other rules of law may prevent some questions from being asked. If the rules permit the question and the answer is available, an answer will be given at the earliest opportunity. When we do not ask a question, that is no reflection on the person asking it. You should attach no significance to the failure to ask a question. I will apply the same legal standards to your questions as I do to the questions asked by the lawyers. Admonition. I'm going to give you some do's and don'ts, mostly don'ts, which I will call the admonition. The admonition applies at all times during the trial. Before each recess, I will not repeat the entire admonition. I'll probably refer to it by saying, please remember the admonition, or something to that effect. However, even if I forget to make reference to it, please remember that the following admonition still applies at all times during the trial. Wear your juror badge at all times in and around the courthouse so everyone will know you're on the jury. Again, that badge is in the notebook in the front. You are to determine the facts of this case only from the evidence that is presented in this courtroom. Arizona law prohibits a juror from receiving evidence not properly admitted at trial. Therefore, do not do any research or make any investigation about the case on your own. Do not view or visit the locations where the events of the case took place. Do not consult any source, such as a newspaper, dictionary, reference manual, television, radio, the internet, or any other electronic media for information. If you have a question or need additional information, submit your request in writing, and I will discuss it with the attorneys, same as you would a question for a witness. If you do encounter something about this case outside the courtroom, in your exposure to it immediately, report it to me through the bailiff as soon as you can. Do not talk to anyone about the case or about anyone who has anything to do with it, and do not let anyone talk to you about those matters, until the trial is ended and you have been discharged as jurors. This prohibition about not discussing the case includes using email, Facebook, MySpace, Twitter, instant messaging, BlackBerry messaging, smartphones, Snapchat, Instagram, Google, Yahoo, any other internet search engine, or any other form of electronic communication for any purpose whatsoever if it relates in any way to this case. This includes, but is not limited to, blogging about the case or your experience as a juror on this case, discussing the evidence, the lawyers, the parties, the court, your deliberations, your reactions to testimony or exhibits, or any aspect of the case or your courtroom experience with anyone whatsoever until the trial has ended and you have been discharged as jurors. Until then, you may tell people you're on a jury, you may tell them the estimated schedule for the trial, but do not tell them anything else except to say you cannot talk about the trial until it is over. One reason for these prohibitions is because the trial process works by each side knowing exactly what evidence is being considered by you and what law you are applying to the facts you find. As previously told you, the only evidence you are to consider in this matter is that which is introduced in the courtroom. The law that you are to apply is the law I give you in the final instructions. This prohibits you from consulting any outside source. If you have cell phones, laptops, or other communication devices, please turn them off and do not turn them on while in the courtroom. You may use them only during breaks, so long as you do not use them to communicate about any matter having to do with the case. You are not permitted to take notes with laptops, smartphones, BlackBerries, tape recorders, or any other electronic device. You are only permitted to take notes on the notepad provided by the court. Devices that can take pictures are prohibited and may not be used for any purpose. It is your duty not to speak with or permit yourself to be addressed by any person on any subject connected with the trial. If someone should try to talk to you about the case, stop him or her or walk away. If you should overhear others talking about the case, stop them or walk away. If anything like this does happen, report it to me through the bailiff. When I say bailiff, that could be any security officer. He might be close by. As soon as you can. To avoid even the appearance of improper conduct, do not talk to any of the parties, the lawyers, the witnesses, or any media representatives, and while they won't be in the courtroom, there could be people such as this in the building, about anything until the case is over, even if your conversation with them has nothing to do with the case. A simple greeting in passing, however, is permissible. The lawyers and the parties have been given the same instruction about not speaking with you as jurors, so do not think they are being unfriendly to you. You go home this evening and family and friends ask what the case is about, remember you cannot speak with them about the case. All you can tell them is you're on a jury, the estimated schedule for the trial, and that you cannot talk about the case until it is over. In a civil case, the jurors are permitted to discuss the evidence during the trial while the trial progresses. In a criminal case such as this, however, the jurors are not permitted to discuss the evidence until all the evidence has been presented and the jurors have retired to deliberate on the verdict. You may not discuss the evidence among yourselves until you retire to deliberate on your verdict. Therefore, during breaks and recesses, whether you are assembled in the jury room or not, you shall not discuss any aspect of the case with each other until the case is submitted to you for your deliberation at the end of the trial. Again, if you have a question or need additional information, submit your request in writing and I'll discuss it with the attorneys. And you can do that through the bailiff or court security. During the trial, you are not to engage in any conduct that impairs or interferes with your ability to hear and understand the court proceedings. Do not form final opinions about any fact or about the outcome of the case until you have heard and considered all the evidence, the closing arguments, and the rest of the instructions I will give you on the law. Keep an open mind during the trial. Form your final opinions only after you have had an opportunity to discuss the case with each other in the jury room at the end of the trial. If at any time during the trial you have a difficulty hearing or seeing something that you should be hearing or seeing, or if you get into personal distress for any reason, raise your hand and let me know. If you have any questions about parking, restaurants, or other personal matters relating to your jury service, please ask one of the court staff. Again, court security would be your primary person. But please remember the admonition applies to the court staff as it does to everyone else, so do not try to discuss the case with court staff. At this point, I want to provide you with a phone number, and this is for the court's judicial assistant. Her name is Aileen, and this is a number you could call if, say, you had a flat tire, you're running late, you'd be able to call and let her know. You can write it on one of the pages in your notebook. And that number is 432-8520. 432-8520. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of the charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced the defendant is guilty of the crime charged, you must find him guilty. If, on the other hand, you think there is a real possibility the defendant is not guilty, you must give him the benefit of the doubt and find him not guilty. You will decide what the facts are from the evidence presented here in court. That evidence will consist of testimony of witnesses, any documents or other things received in evidence as exhibits, and any facts stipulated to by the parties or which you are instructed to accept. You will decide the credibility and weight to be given to any evidence presented in this case, whether it is direct evidence or circumstantial evidence. Direct evidence is a physical exhibit or the testimony of a witness who saw, heard, touched, smelled, or otherwise perceived an event. Circumstantial evidence is the proof of a fact from which the existence of another fact may be inferred. You must determine the weight to be given to all evidence without regard to whether it is direct or circumstantial. Neither side is required to call as witnesses all persons who may have been present at any of the events disclosed by the evidence, or may appear to have some knowledge of these events, or to produce all objects or documents mentioned or suggested by the evidence. During the trial, the lawyers are permitted to stipulate that certain evidence exists. This means both parties agree that evidence exists and is to be considered by you during your deliberations at the conclusion of the trial. You are to treat a stipulation as any other evidence. You are free to accept it or reject it in whole or in part, just as any other evidence. As mentioned, it is your job to decide from the evidence what the facts are. There are 5 rules on what is not evidence. The lawyer statements. Ordinarily, statements or arguments made by lawyers in the case are not evidence. Their purpose is to help you understand the evidence and the law. Questions to a witness. By itself, a question is not evidence. A question can only be used to give meaning to a witness's answer. Objections to questions. If a lawyer objects to a question, and I do not allow the witness to answer it, you must not try to guess what the answer might have been. You must also not treat the objection as evidence or guess the reason why the lawyer objected in the first place. Rejected evidence. At time during the trial, testimony or exhibits will be offered as evidence, but might not allow them to become evidence. Since they never become evidence, you must not consider them. Stricken evidence. At times I may order some evidence to be stricken or thrown out. Since that is no longer evidence, you must not consider it. A defendant in a criminal case has a constitutional right to not testify at trial, and the exercise of that right cannot be considered by the jury in determining whether a defendant is guilty or not guilty. If there is testimony in this case about what a defendant said to a law enforcement officer, you must not consider any such statement until you determine, beyond a reasonable doubt, that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by law enforcement officers' use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statements you feel it deserves under all the circumstances. Admission of evidence in court is governed by rules of law. I will apply those rules and resolve any issues that arise during the trial concerning the admission of evidence. Do not concern yourself with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that was admitted. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says, or part of it, or none of it. In evaluating testimony, you should use the test of accuracy and truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see, hear, or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness has any motive, bias, or prejudice, whether the witness is contradicted by anything the witness said or wrote before trial, or by any other evidence, and the reasonableness of the witness's testimony when considered in the light of all the other evidence. Consider all the evidence in light of reason, common sense, and experience. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise, may also state reasons for those opinions. Expert testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. The rule of exclusion of witnesses is in effect and will be observed by all witnesses until the trial is over and the result is announced. That means that all witnesses will remain outside the courtroom during the entire trial except when one is called to the witness stand. They will wait in the areas designated by the bailiff until other arrangements have been made with the attorney who has called them. The law also forbids witnesses from telling anyone but the lawyers what they will testify about or what they have testified to. If witnesses do talk to the lawyers about their testimony, other witnesses and jurors should avoid being present or overhearing. The lawyers are directed to inform all witnesses of these rules and to remind them of their obligations from time to time as may be necessary. The parties and their lawyers should keep a careful lookout to prevent any potential witnesses from remaining in the courtroom if they inadvertently enter. There are exceptions to the exclusion of witnesses. The case officer is allowed to remain in the courtroom during the trial. The defense investigator is allowed to remain in the courtroom during the trial. And the court has authorized that 2 members of the alleged victim's family will be allowed in, even if they may be witnesses. And this next part, you did see some of you a couple of times during jury selection. From time to time during the trial, it may become necessary for me to talk with the attorneys after the hearing of the jury, either by having a conference at the bench when the jury is present in the courtroom, or by calling a recess, which means you would be excused from the courtroom. Please understand that while you are waiting, we are working. The purpose of these conferences is not to keep relevant information from you, but to decide how certain evidence is to be treated under the rules of evidence and to avoid confusion and error. We will, of course, do what we can to keep the number and length of these conferences to a minimum. I may not always grant an attorney's request for a conference. Do not consider my granting or denying a request for a conference as any indication of my opinion of the case or on what your verdict should be. Please do not be concerned with what we are discussing at any bench conference we may have. Please respect the privacy of those participating in the bench conference in order to maintain the fairness of the trial. I think that is a nice breaking point for lunch. So we'll now take our lunch recess. Remember the admonition, read to you a couple more minutes ago. And we will start back at 1:30. And again, because we're moving people around, I'll ask Officer Luna, when they come back, well, obviously my jury room is available. Do we have another jury room available also to split them up? Okay. And with these individuals, are they familiar with the locations of those two rooms? Okay. And there's you were there earlier this morning, a little sign, Division 1, Division 4. So if y'all would gather in there as you come back from lunch. And that way, in case other people need to speak in the lobby or something, you're not nearby. And then the bailiff will bring you over when we resume. And my goal is to make that right at 1:30. So I will now, you leave wear your badge, your juror badge, right? Get that out. Otherwise, leave the notebook and the contents on the seat that you'll be returning to. Once I see everybody has their badge on, I'm going to ask everyone else to stand and we will excuse the jury. I think people have their badges, so thank you. Enjoy your lunch. Jury's excused. All right, please be seated. No member of the jury is present in the room. Any need for us to come back before 1:30? Ms. Zucco?
No.
She says no. Mr. Kimminau?
No, Your Honor.
Okay, we're going to aim Mr. Kimminau for 4:30 is my goal. And I'll say something, let you know, hopefully, when we come back at 1:30 before they're brought in for the training and the testing of the Zoom.
Okay. Can I have access to the courtroom during the lunch hour, or is it completely locked up and no access?
Well, it's locked up.
All right,
Yes.
so any books or anything I need to take with me.
If you're going to use them during, yes, sir, thank you.
All right.
Sorry. All right, enjoy lunch.
Please rise.
Have lunch?
No.
No, not much.
We did take a break to satisfy our tobacco thirst. So I had a chew and he had a part of a cigar. Well, that was very important anyway. Yeah. And then we worked. Worked.
He's always been good for,
He's a slave driver.
he's a stand-up guy right there.
Yeah, he's a slave driver.
When I used to pour concrete, I always had these jobs where the boss would be like.
Are you figuring out the thumb drive?
Whenever I was capital and stuff like
We
that.
need to have something that's gonna be like a provisional exhibit that we're gonna enter that has the 911 call on it that we're gonna play.
The work's already done when the boss gets in. When the boss shows up, they'll
You
turn
want me
around
to
and
get
go,
the thumb drive?
What we're gonna do is,
Oh, that was not me.
oh,
Let's see,
Thank you.
actually,
Okay, but let me just, tell you what's
You've
my
always been a good boss to everybody.
We're gonna
I
go
don't
to
even-
get the 911 call. But
This
the problem is
situation right
this,
now, I don't know what
okay,
would happen.
it's gonna be on a thumb drive, it's gonna have all the admitted digital media, but we're still working on it, so it's
I
like,
know it happens, but
we don't want it.
Shoulda, shoulda, woulda,
We don't want it like.
I know. Where were you gonna be?
That's just one, too. Yeah, but we're not gonna give it to you. Because we're gonna
final-
make that-
He's here now.
What was your final?
So that's what she's gonna play.
But that's fine, because I can remove
The final
people on my
job?
attached tonight, so.
Sorry.
What was your
Thank you.
final job you got this year?
Acting sheriff.
The acting sheriff?
Yeah, and I was chief deputy, and then Mary Beaver was killed in an accident. So I was acting sheriff for about the last thing.
Never had a desire to do that job, huh?
Well, I ran, but I had to run as a write-in candidate.
Oh, so it was too late. Okay. And then you retired after that?
Yeah, and I started doing the PI thing primarily to pay the cost of health insurance.
Outrageous, isn't it? Outrageous.
I was paying like $1,680 a month.
Yeah, I know, that's what I know, it's outrageous. And then over time, they keep wanting to jack your deductibles up to keep the same rate, or it goes up or whatever. Now what do you want, Social Security or Medicare or whatever?
I'm on Medicare
I was
now.
trying.
I have a Medicare Advantage plan, and that dropped my health insurance by like $600 a month.
I'm not that old
But I
yet.
robbed the cradle, so I gotta carry the wife along for a while.
Well, no, send her to work. If you rob the cradle, you need to send her to work. Tell her to get a job with benefits.
When were you?
When? No, I was the city police officer in Colorado Springs. That was a long time ago, 1981 to 85.
You and Joe Kendrick.
Joe Kendrick was one of my sergeants.
Huh?
Yeah. Don't ask me about Joe Kendrick.
I won't.
Yeah. No. Suffice it to say, he was one of my sergeants. Do you actually know him from something or just from a TV show?
Just a TV show.
Yeah.
I had an uncle who lived in Colorado Springs. He was Air Force, of course, when he was there. He passed away about a year or so.
I was not there that long in retrospect,
All right.
4 years.
Okay, thank you. Please be seated. We're back on the record and state the Wilson after lunch. Jury's present, attorneys and Mr. Wilson are present, and I will continue with the reading of the preliminary instructions. I am on page 10, alternate jurors. The law provides for a jury of 12 persons in a case such as this. In any case lasting more than a day, we seek one or more alternate jurors so that if a juror becomes ill or has a personal emergency, the trial can continue without that juror. In this case, we have seated 2 alternate jurors. At the end of the trial, the alternate jurors will be determined by lot in a drawing held in open court. Until then, each of you must consider yourself a juror in this case in every respect. Please do not be concerned with who may or may not be an alternate. Before the jury retires to begin deliberations, the alternate jurors will be permitted to go home, but will not be excused. An admonition of the court will continue to apply. When the jury concludes its work, the alternate jurors will be notified of the verdict
and the admonition of the court will no longer apply. In the event a juror is unable to proceed or is otherwise disqualified during the deliberations, an alternate juror will be substituted for the dismissed juror, and the jury will be instructed to begin deliberations from the beginning to fully include the replacement juror. Criminal trials generally proceed in the following order. First, the prosecuting attorney will make an opening statement, giving a preview of the case. Defendant's attorney may make an opening statement outlining the defense case immediately after the prosecutor's statement, or it may be postponed until after the state's case has been presented. What is said in opening statements is not evidence, nor is it an argument. The purpose of an opening statement is to help you prepare for the anticipated evidence. Second, the state will present its evidence. After the state finishes the presentation of its evidence, the defendant may present evidence. If the defendant does produce evidence, the state may present additional or rebuttal evidence. With each witness, there is a direct examination, a cross-examination by the opposing side, and finally, redirect examination. This usually ends the testimony of that witness. Third, after all the evidence is in, the attorneys will make closing arguments to tell you what they think the evidence shows and how they think you should decide the case. The state has the right to open and close the argument since the state has the burden of proof. Just as in opening statements, what is said in closing arguments is not evidence. Fourth, I will read and give you copies of the final instructions, the rules of law that you must follow in reaching your verdict. Fifth, you will decide in the jury room about the evidence and the rules of law and decide upon the verdicts. Once you agree upon the verdicts, it will be read in court with you and the parties present. Finally, you'll be discharged and released from the admonition. The trial, as I said earlier, is expected to last, would be 12 days. I say 3 weeks, but 12 days because we'll run Tuesday through Friday. We're getting off a little bit behind schedule, and that's understandable due to the restrictions created due to the virus. But we'll do our best to move the case along, but delays will frequently occur. Those won't be anyone's fault, so please don't hold them against the parties. Delays usually occur because the attorneys and I often need to resolve certain legal matters before these matters may be presented to you in court, or because I am busy with emergency matters and other cases. The usual hours of trial will be 9 a.m. to 4:30 p.m. Not aware of any exceptions at this time. They may come about as the need arises. We'll take a short recess about mid-morning and mid-afternoon. We will recess at noon and begin again at 1:30 after lunch. Unless a different starting time is announced prior to recessing for the evening, you may assume a starting time at 9 o'clock a.m. for the next day. At the beginning of the day, please assemble, and at least until further notice, you'll be assembling in jury rooms number 4 and 1, where you came to after lunch. 14 of you, I'd suggest 7 per room. Now, we'll always have Division 4's jury room. We may need to find an alternate spot if Division 1's jury room is occupied. And I think probably last resort, I don't mean that's negative because it's been done in other trials this year, we may use the court's jury room, Division 4's, and just have the other 7 people out here in the lobby spread out. But you'll be informed. Please do not come back into the courtroom until you are called by the bailiff. The charge is on the second page. It's sort of abbreviated, but it's, I believe, understandable as to what the charge is. I will not read it again since you just heard it. You must not think the defendant is guilty just because of this charge. The defendant has pled not guilty. The plea of not guilty means the state must prove every part of any charge beyond a reasonable doubt. The rules of law I've shared with you in the past few minutes are preliminary only. At the end of the case, I will read to you and you'll receive a copy of the final instructions. In deciding the case, you must be guided by the final instructions. Excuse me. Now the attorneys will be permitted to make their opening statements. As I said a moment ago, what the lawyers say in their opening is not evidence. It's simply an outline of what the lawyer thinks the evidence will be. It's offered to help you understand and follow the evidence during the trial. Ms. Zucco?
Thank you, Your Honor.
And I'll apologize for interrupting already. I'll remind the attorneys, to the extent possible, try to be near their microphones, and they certainly may move those to the corner closest where they plan on standing. Thank you, Ms. Zucco.
Thank you. Good afternoon, ladies and gentlemen. On June 22nd, 2017, at around 1 o'clock in the morning, this man, Roger Wilson, shot J.D. Arvizu with a 20-gauge shotgun in the middle of the street. J.D. was unarmed. It was at fairly close range, about 6 to 9 feet. And it went in the side of J.D.'s chest on the left, below his nipple. And it was at a downward angle, and it went left to right, front to back. It was birdshot, like I said, 20-gauge shotgun, and it had mass destruction on JD's organs. After he shot JD, who was a 23-year-old kid walking to his friend's house in the street, unarmed, wearing a tank top and shorts, JD was still alive. And JD then ran away from Roger Wilson, who just shot him at fairly close range with a shotgun. And he ran south to his friend's trailer, where he was headed in the first place, Jose Sanchez's trailer. And he ran 160 yards south to that trailer. During that time, this man, Roger Wilson, followed JD, trying to reload that shotgun, watching him bleed out, listening to him screaming for help. Followed him to very near the trailer. He had a flashlight with him. And you'll see where that flashlight, where he dropped that flashlight, and where it was found by the police. Across sagebrush, very close to that trailer. He's following him, trying to reload, while JD's bleeding out. And he hears him screaming for help from his friends. And in fact, JD screams out, "Louie, Louie." And his friends inside the trailer hear this, and at least one of them heard the shotgun. And they come out, and they see JD struggling, falling over, gasping for breath, blood everywhere. And they see a man, they don't know it's Roger Wilson, but they see the man coming towards him with the flashlight, still coming after him. They get JD, they drag him or get him up and hold him up and get him into the trailer. He's still alive at this point, and they're able to call 911. Meanwhile, Roger Wilson gets startled after he yells out, "Louie, Louie," and they come out, drops the flashlight, and then he heads back to where he shot JD, which is in the street across from the gate to where his mother lives, a little bit back. It's a pretty big property. And He pulls his truck into the gate and he parks it in the yard amongst all of these other vehicles. It kind of looks like a car junkyard in the front yard. So it's at least an acre lot. And then he goes inside the house and he cleans the murder weapon and he takes it apart. He disassembles it into 3 pieces. And one piece he wraps in a towel and puts in a location, and another piece he has by it, but it's sort of concealed in this pile of laundry. You'll see the photos of the interior of this house. I don't know how to describe it other than a hoarder house. And then the third piece, the foregrip, is never recovered. We don't know where he hid it. And he sits there and he waits in that house with his mother. Now, meanwhile, let's go back to where JD, where his friends came out and pulled him inside when Roger Wilson was still pursuing him, reloading his gun. So they get him inside, and the female who's there calls 911. That 911 call is at 1:14 a.m. Police arrive shortly thereafter, and the medics are right there too. They wait until the police clear the trailer. When the police arrive, one deputy, Meza, stays with JD while the other 2 deputies clear the trailer. And he asks JD, "Who shot you?" And JD says, "Roger." After that, they clear the trailer. The medics come in and see what they have, gaping gunshot wound. They put a seal on it, and they do I think they call it a load and go, and they just take them off to the hospital. And it's pretty quick in time from the 911 call to when they're en route to the hospital. From there, one of the people in the trailer tells one of the officers, if I were you, I heard where the gunshot came from, and something about I know there's a guy who lives up there who spotlights people. I would start my investigation up Santa Elena, north on Santa Elena. So Deputy McNeely and Deputy Tobolsky do that. They walk north on Santa Elena, and they find the first drops of blood in the street, 2 to 3 feet, you'll hear the exact measurement, from the side of the road, the side of the west side of the road, or the first drops of blood. And looking over is the gate to Roger's mother's house. They see that blood, and Deputy Tobolsky has spray paint that you use for like an accident reconstruction, where you see like circles on the roadway when you're reconstructing an accident. And he starts circling the blood drops. And they start following that trail of blood from the middle of the street across the gate from Roger Wilson's mother's house south towards the trailer where they were just coming from. After they find, several drops of blood and they've circled that trail, Deputy McNeely realizes, hey, because they had already been taping off the crime scene of the trailer, he says, hey, we have a bigger crime scene here. So he tells Deputy Tobolsky, we need to block off this blood trail, this roadway. So Deputy McNeely takes his sheriff's SUV vehicle and blocks off the roadway north of Roger Wilson's mother's house on Santa Elena with his lights on to block off the roadway. And this is a dark street usually. And Deputy Tobolsky moves his car from the area where the trailer is to block off the road south on Santa Elena. So now you have a sheriff's vehicle with lights on north of the gate to Roger Wilson's mother's house and south of the gate. I mean, not right there, but a little bit a ways away on what's usually a pitch dark street. And they are there in that position just after 2 o'clock in the morning. Remember the 911 calls 114. By 2:10, Sergeant Bushel, their supervisor, shows up. And he talked to them about the situation, and they said, yeah, we think, because they had already been running the name, that there's a sign out front, Wilson, running the name, they see that there's and they had the first name Roger from JD, so they see that there is a Roger Wilson associated with that residence, and they have a discussion that, wow, now we're almost an hour after this shooting, he thinks that there's going to be some sort of barricaded shooter in the house, and he's a SWAT person, so he thinks to start activating SWAT. But he knows from his SWAT training that he's going to have a perimeter of that house. So he takes his sheriff's vehicle, which is a fully marked pickup truck, and he drives it around to the alley behind the Wilson property, where he has his back deck lights on, again, like the sheriff's emergency lights, and spotlights the yard. All the sheriff's vehicles have a spotlight on the driver's side. So now, the Wilson residence is basically triangulated by sheriff's vehicles that have lights on that are blocking the scene. And it is not until 2:44, an hour and a half after the first 911 call, that this man, Roger Wilson, then calls 911 to report that he shot JD. Again, after he's been in his house, after he's moved his vehicle, closed the gate, cleaned the murder weapon, taken it apart, and hidden it. An hour and a half later, the sheriff's deputies are already there. I mean, he walks out of his house talking on the phone to 911 and says hi to them. And one of the deputies, Tobolsky, he knows personally, his first name's Leo. So he says, hey Leo, hey Roger. And he says, yeah, I shot that man, I shot that boy. Well, who'd you shoot? JD, I think his name's, last name maybe Arvisu. Oh, what'd you shoot him with? My 20 gauge shotgun? Oh, well, where is it? Oh, it's right inside the door. Okay, well, Roger, why'd you shoot him? And he says, well, we've been having problems for a while. And then he talks about an incident with JD the week before where JD cut his nose. And that's it. It's the extent of their conversation. Meanwhile, the medics and the EMTs went, 2 medics and 1 EMT in the back and 1 EMT driving to the hospital. They arrived at the hospital about 1:48. And they had to implement life-saving measures in the hospital just to get JD to the hospital. And they had already had a rendezvous set up with Airback to get him to Tucson. Okay, this is a fatal wound. They'll tell you the details of what they did. They had to sedate him in order to intubate him, and he has a pulse when they arrive at the hospital. They load him onto the helicopter, and boom, he codes, he dies. Roll him into the ER. The ER doctor brings him back. They roll him back out to the helicopter. Boom, he crashes again. This goes on for quite some time. Lots of life-saving measures are going on at the hospital with the ER doctor to try to get him airlifted to Tucson. Then detective, now Corporal Borges, gets an x-ray from the emergency room that shows the trajectory of the pellets and how they go in at an angle. They enter here and they end up in the stomach. And again, I'm indicating on the left side. And, he sends that to his sergeant. So they see, what they're looking at. What kind of, they're trying to put the scenario together of what happened in the street there. While Detective Borges is on his way to, excuse me if I keep calling him that, he's corporal. While he's on his way to the scene, he calls the hospital just to say, hey, when airback takes him, can you let me know? And they said, oh, we pronounced him dead at 4:17. His mother was there that night, and their whole family. And that night changed their life forever. 23-year-old kid, unarmed, walking to his friend's house in the middle of the street with a tank top on and shorts. So, earlier that morning, a few hours later, Detective Borges and Detective Jamka interview Roger Wilson, and they talk to him. And they also interviewed some other witnesses in the days afterwards to try to piece together what happened. And they learned that, in fact, JD had been at the same house, Robert Burton's house, as Roger Wilson earlier that evening, like just 10, 15, 20 minutes before the shooting. Robert Burton lives, we'll have maps during the trial, but Santa Elena is a north-south street that's 1 block east of Highway 92, down it used to be the Giant, it's now the Speedway on 92. It's Sierra Vista Estates. That's the neighborhood, okay? So they're at Robert Burton's house, and you're gonna hear, this is basically a drug house. Most of the people that go there, not all the people that go there, but most of the people that go there are using drugs or doing drugs. So they were there with some other people just prior to the shooting. And while they're there, JD and Roger were having some words. And you're going to hear witnesses say that Roger Wilson was the one who was being the aggressor that night, not JD. He was antagonizing JD. And then you're going to hear witnesses say that while he was antagonizing JD, that he put his hand on a gun that he had in his vehicle, in his truck. And that was the shotgun or the handgun, they weren't sure what they saw, but they saw him reach for a gun, put his hand on a gun, and then they heard JD say, 23-year-old kid, hey, next time you pull a gun on me, you better use it. Not a smart thing to say. Roger admitted to Detective Jamka and Corporal Borges that he did have the shotgun that was the murder weapon, the 20 gauge, in his truck at Robert Burton's house. He admitted to them that he loaded it at Robert Burton's house after he had worked with JD, and he told the detectives that he doesn't load a gun unless he's going to use it. He doesn't load that gun unless he's going to use it. And sure enough, 10 to 15 minutes later, he used it. He used it on JD Arvizu, a 23-year-old kid who was walking from Robert Burton's house to his friend's house in the street, unarmed, alone, wearing a tank top and shorts, shot him at fairly close range with a 20 gauge shotgun with birdshot right here in the chest, like I said, obliterated his organs. And then followed him 160 yards trying to reload the shotgun, watching him bleed out, callously listening to him screaming for help. And when help arrived, he fled back to his mother's house, started to conceal the evidence, hid the evidence, cleaned the evidence, and sat inside, tried to wait it out until his house was surrounded by police, and only then did he call 911. Ladies and gentlemen, there's going to be a lot of evidence in this case. That's just a preview. When you've heard all of the evidence, I'm going to ask you to return a verdict of first degree murder. Thank you.
Thank you, Ms. Zucco. Mr. Kimminau, would you like to make your opening now or reserve till later?
I'll reserve, Your Honor.
Thank you. And that means we're ready for our first witness, Ms. Zucco. Who will that be?
Your Honor, at this time, if I can approach the clerk. Well, Your Honor, the state is requesting to play the original 911 call. It's marked, and the affidavit is marked. The 911 call is going to be played on a thumb drive that will be admitted later with all of the digital media that's being admitted.
Well, if we're going to play it now, it has to be admitted first?
Let me first of all invoke the rule, Your Honor.
Exclude witnesses?
Yes.
Yes.
I don't think it's been invoked yet.
Actually, I said it was invoked during the preliminary.
I heard you say that.
But it's official now.
Okay.
The rule is invoked, and the attorneys should keep their eye open for witnesses that might wander in before it's time for them to testify. Other than the exceptions I mentioned, case officer, defense investigator, and the two members of the alleged victim's family who I have approved.
I could stipulate to the 911 call, if that's the problem.
So what is the exhibit number?
Okay, the transcript of,
Oh, we do have the transcript that we need to pass out, Judge.
Well, we need exhibit number.
Okay.
of the transcript of Tiffany's Burnside is number 6.
Well, it's a transcript of a 911 call, apparently. Is that Burnside?
Exhibit 3? Yes.
So, but what about the actual recording?
That's what I said, Your Honor. The actual, can we approach?
I suppose.
Okay.
And for our admitted into evidence, there's going to be a recording played, members of the jury, in a moment. There's going to be a transcript passed out, and each of you will have a copy, and that's for you to follow along when you hear the recording. The transcript is just sort of illustrates what the recording may say. You're going to listen to the recording. The recording is what's in evidence. The transcript is just to assist you. But if you think that there's some difference, you go by what you believe the recording says. The transcript will not be coming into evidence, and that will be gathered back from you and disposed of. Ms. Zucco, may proceed.
Well, thank you, Your Honor. I asked Mr. Luna if that would help me.
Yes, he should help you. You got two of them, right? Okay, so each juror has a copy of the transcript, so Ms. Zucco may proceed now with playing the recording. And the recording does not need to be transcribed. A copy of the transcription, the proposed transcription, will be available for the record. We'll deal later with how we're gonna, what number that is.
911, where's your emergency? I'm the ambulance here now, my friend just got shot. I'm at 4110 Stage West. He just got shot by somebody. We don't know who. 4110? Yeah, Stage West. Can you listen to here now? Okay, I'm gonna get you over to here just simply. Right back, please. Well, do you know who got shot? His name is, what's your real name, JD Jose? I think JD, his real name is Jose, I'm not sure. But I don't know who shot him. I said that he knows who shot him. I think it's Jose Origio. Okay, Jose? Yeah. This is like an emergency. Can we hurry, please? Can you get the ambulance on the way right now? We're getting that city started by way, okay, man? Okay, the cops is headed this way. Do you know which way Jose went? He's in my living room. Jose's still there? Yes, he's in my room, my living room, I can speak. Okay, what did he shoot your son with? That's not my son, he didn't shoot me, he got shot. What did Jose shoot your son with? My son didn't get fucking shot either, it's my son that got shot. And I don't know who did, can you get me back here now? Ma'am, I'm trying to get some info from you, we're getting them started, okay? Okay, well, he's down on the ground, like hurt, it's bad. I understand that, we're getting medics started, okay? Where is the person that shot your son? Can you guys stand up here and have, you guys stand up here, I can't have you go to the right. Lay down here, he's worried. What? Ma'am, where is the person that shot your son? Is he still there? I don't know, if it's not my son, he's my friend. Okay, your friend. Yes. Can you get him here now? He's on in the back of the place. Okay, they're on the way. Where's your friend at? Is he still in the house? He's in my living room. Yeah, he's in my living room. Do you know how Jose got there? Was he in a car? Was he on foot? I believe he was on foot, walking over here from his house. Okay. Because all of a sudden I heard screaming in the back. What was he wearing? He was wearing black shorts and a white tank top. It doesn't matter. He's still here. He's injured badly, and I don't know who did it. Okay, ma'am, we have medics on the way, okay? What did he shoot him with? Was it a rifle? I don't know. I don't know. I know what he had. Okay. I can't tell you what it was. I think the guy gunshot. I didn't hear the gunshot. What's your friend's name? His name is Jose Arruzio. Is that your friend? Who shot him? No, I don't know who shot him. You got that? Okay. Okay, do you know who the suspect is, what his name is, anything that we are... I can't! The husband's name is Jose. I cannot tell you who the fuck shot him. You understand me? Okay. Yeah. And my son's a virgin, he's not listening very well. Okay, is Jose wearing the black shorts and the white shirt, or... Yes! No! He said, I can't tell you the fucking suspect, dude! Okay, ma'am, we have everybody heading there as fast as they can, but we need to know who we're looking for as well. I don't know who the fuck you're looking for. Okay, is he still in the area? He's staying on the here. I'm not talking. Maybe they are. I don't know. Okay. You get that? But then he's not in the house at this time. He's laying on my fucking floor. He's walked up to my house from down the street. Okay, and who else is in the home with you? He's living with myself. Okay.
14492, 84.
Probably 118. Okay, I have 3 units heading there as well as the medics, okay? Stay with me on the phone. Yeah, no, what are you doing? You come over here.
I'm just trying to turn on the same room.
Okay, if there's any way someone can hold the door open, that way the medics can come in? Yeah, if you can, you hold it open, but it doesn't matter. Really, I mean, it's just okay. That's right, I heard him as you speak. Right here. It's right here. Disregard that. I heard him, I'm sorry, but I haven't stopping. I don't understand it at all. Tell them to turn right on the 1st Street. Turn right? Because I'm in the teleport on the corner.
Okay, 135, 144.
Hold on, baby. Okay, they're going to see me right off the street right now. Okay, ready? Yeah, don't turn. Thank you.
Okay, so the transcriptions have been recovered from the jury, and I was a little unclear. It is marked, it's number 3, State's Exhibit 3, not admitted to evidence. Next, Ms. Zucco.
Thank you, Your Honor. The State calls Deputy Meza. Oh, Your Honor, we need to publish a photo from this witness, so we need the television monitors on.
I can do that.
Can we approach what's doing that?
Well, let me get it done. I won't be able to listen to you and do it at the same time. Okay. You may approach now. So, Deputy, could you please stand in front of the clerk and be sworn?
Do you swear to protect the truth, the whole truth, and nothing but the truth during this proceeding, so help you God, or so you do affirm?
Yes, I do.
Thank you.
Have a seat to my left, please. And once he is seated, and I'm going to ask him when he sits down to move his chair to the left as much as it will go, without him still being there, correct. And now I'm going to ask the jury, and I know there's people in the jury box, they're not going to have a problem, but is there any member of the jury who is unable to see the witness? Okay, so we have one hand, and that is it 34? Ooh, I got it right. All right, so if you were to move your chair with the bailiff's help, perhaps, so that you're sort of more to your left, would that help? He'll help you. So number 34, is that better? You want him to go to the right?
No.
So the bailiff is adjusting 34's chair. Oh, it's moving to a different seat. Is that better, 34? She can see now. And by the way, particularly for those who are outside the box, if you cannot see a witness, and for everybody, if you cannot hear someone, it's like someone told me earlier to lower my mask, and that was fine. Do something. You raise your hand, interrupt, let us know, because we can move some of you who are sitting in the back. I sort of designated those spots based on what I thought would work best with you being spread out. And I'll ask each witness to speak up so that they can be heard.
Yes, sir.
And to lower their masks so they'll be easier to hear. And is that 7? What's your number, sir? If your hand up? 7.
Yes, I just, by looking over here, I think I recognize the defendant.
Okay.
And he...
Oh, why don't you come up and give us those details up here so that just the lawyers and I can hear you. Okay, the court's giving Mr. Kimminau a chance to speak to Mr. Wilson. Obviously, it'd be very not practical to bring Mr. Wilson up to each one of these conferences, but he needs to be filled in.
Can you keep the
Yes, I will, given this may take a little longer talking than normally, I'll keep the white noise on until I'm given a signal. Number 7, you're going to be excused. So thank you for being here. Thank you for sharing your thoughts. Please leave your notebook and your badge on your seat. If you took any notes, those will be destroyed. And you are excused. You will not be calling back, so no admonition applies to you. And actually, let me go and excuse the deputy. You'll go back up to the lobby. Yes, Your Honor? So the witness and number 7 are no longer in the courtroom. Ladies and gentlemen, I'm going to need to send you home early today. I'm concerned about a proceeding with just one extra juror, given this is day 2. So you're going to be excused to come back at 9 o'clock tomorrow. Jury room 1 and 4. The attorneys in the court are going to remain, and Mr. Wilson, and determine if it's feasible to bring in a replacement. If there is a replacement, then the opening statements and the recording will need to be replayed to bring that person up to speed with the rest of them. So please remember the admonition, take your badges home, leave your notebooks on your chair. No one will disturb those. They'll be there when you come back in tomorrow morning. Thank you.
Please rise.
You want to stay for this, or do you want to go back?
I used to see it was to check I'm out the mail. I also wrote 2 months.
What?
I also wrote my name down and comes up when he shows up.
All right, have a seat, please. Now let's wait for the door to close. It's closing. There's no member of the jury present. Attorneys and Mr. Wilson are present. Do the attorneys have their list, the list with the strikes and so forth on there? If you could get your copy out.
I might.
And I'll ask Officer Luna, the copy you had, do you know where it's at? Okay, so you can,
Yes.
You have yours, Mr. Kimminau?
I do have one.
Okay, so let me have the copy in case I need a mark on it. I don't want to disturb the original. Okay, I'm looking at the copy of this, the one that Aileen gave you that when you were calling names over. She gave you a copy of this. Okay, so I'm not gonna go through those now. All right, so I'll use the original. Mr. Kimminau, have you found yours yet, or do we need to get a copy made?
What I have is the list that we used to do the strikes. Yeah, that's what I have, with the strikes on it.
Yes, that's what we were all looking for.
Yeah, that's what I have.
Okay, we now have a copy also. Thank you. All right, so this is new to me. Haven't had this happen as a judge or an attorney. But my thought is, attorneys, look at the next couple of people on the list. Is the one the 2 of you can agree to. I would then have that person called. You would sit tight because, of course, this person might get a phone call and they may say, I made plans For some reason, I just impossible for me to come in tomorrow.
We would also have to ask them if they've broken the admonition.
Which means likely the court will have to talk to them, because only so much I can have my assistant do.
Right.
So I'd probably make the phone call myself. But yes, that would be another good
And
point.
can we agree that this person will be an alternate if numbers permit it?
Mr.
Because-
Mr. Kimminau?
I mean, I don't, this is like uncharted territory. I think it's cleaner if we just make this person the alternate.
Well,
I guess that's fine.
well, both parties agree. I'm not against it.
It
I mean,
just
to me,
makes
this
sense.
person has missed very, very little. But if it helps as far as the two of you agreeing on a person, then I'll go along with you.
I think it helps as far as this becoming an appellate issue, because then if they're the alternate, then it doesn't
Right.
come into play.
All right, so can the two parties agree on one of these individuals for the court to call with the understanding that numbers, if there are a sufficient number of jurors, in other words, 11 or more, this replacement person will be excused at the end as an alternate?
I propose 53.
I think we should just go in order.
Well, we are going in order, but I mean, if the two of you agree, if for some reason the defense would have struck in 46, who's actually the next one, well, then I don't want to force 46.
Yeah, that's the problem.
Well, let's see what she says about 53. And I have no recollection of any of these people, but
Oh, yeah, we're fine with her.
Or 50?
I want more than one, because I like to, so 53 is choice number one. I heard that from both sides.
Yes.
Can
Hold on,
50
Hold on just a second, because
Okay.
my client has an input. 50. You like 50, okay, so 50, you want that, are you agreeable to 50?
45, 50 and 45.
No, 45 is, no, that's not one of the options.
Okay, no,
About
I
40.
don't want to agree to 50.
About 40.
Okay, so far I have that 53 would be agreeable to both, but we can,
46. Okay, so let's try 50, what did I say, 53?
53,
Okay,
52.
53 and 46 are fine.
You think about 46 to go, you mentioned 46.
Yeah, 46 is okay. Oh, 46. 46 is enough.
yeah, so we don't want to agree on 46.
well, let me call 53, because I don't want to drag things out, and 53 is just no problem.
Right.
Okay.
And I'm going to explain that someone had to be excused unexpectedly. I need them to come back in, and I'll see what they say. And then I will ask about, have you done any research? Have you read something about this case? And depending on what the answer is, if it's no, then we're good to go. If the answer is yes, let me put the person on the speakerphone. Because again, depending on what they saw, it might be something that they could set aside.
Right.
So, y'all will be on a break, and I've written down 53. I'm going to
Can you
make
turn the
that phone call.
white noise on?
Say again?
Can you turn the white noise on when we go on break?
Yes, I can do that as I get up. All right? So, I'll make a phone call to 53. Thank you. Be seated, please. We're back on the record. Attorneys and Mr. Wilson are present. I called 53, and we're not going to be able to bring her back. She is a school teacher, and she just rescheduled her parent-teacher conferences for next week. And given I told her she was excused, I really did not feel comfortable trying to lean on her anymore, even though I told her that she was the first choice of both sides. So if the attorneys will please look at the numbers, and I'll try again. And if we get two, that would save a little time just in case.
46. Works for the court, works for the...
Right.
How about 46 and 54?
46 was from office.
Well, 46 was offered by defense earlier, Ms. Zucco, so if you're okay with that one, they should be.
She works for she's a CASA, court-appointed advocate.
Special advocate.
So I thought I heard
She works for the court, not my office.
That was the number that you liked. You liked 46, right?
Yes, either Mr. Wilson or Mr. Kimminau nominated 46.
No, I like 50, 45.
Well, 45 is not an option.
Okay, 45 is on the jury.
Yeah, 45 is not an option, it's before the...
Right, but you have 45.
Right, so 46 you did not like, so, okay.
50 was good.
Okay, is that a yes or a no to 46, Mr. Kimminau?
No to 46 right now, Judge.
All right.
50, but I asked you about 50 earlier and you said no. But no, you said no to 50, right?
I said no to 50.
Oh, they said no to 50. Okay.
54 is she?
Okay, I don't think really need to have a record on this interchange right now. So that's on me. We're not going to be transcribing this till I say we're back on the record.
Okay.
And I won't say that until I have a number written down.
Right, okay.
54.
54?
Yeah.
54?
54, she was, yeah, I think I was okay with 54.
Okay. 54 is Samuel.
She's retired and married, if I remember right.
No, it's a male, Samuel. Works for the post office, it says. My notes say. Just try 54, Judge.
Ms. Zucco?
That's fine.
So I'm writing down 54. Can I get another number?
What, are we playing bingo here or something, or what?
Well, I will give it a try. Y'all don't go to the restroom or anything. I was amazed, we're still off the record. I was amazed that the woman answered the phone on like the second ring. So I was off to a pretty good start with that. So I'm not on the record yet still, because I'm trying to squeeze another number out of the attorneys.
56.
Okay, look at 56, Roger. I'm okay with that. Wait until he looks. And by the way, while he's doing that, Your Honor, I'll do this on the record, but I request that none of the witnesses wear masks. I don't think it's appropriate for them to be wearing masks.
Well, I don't see that inconsistent with what I just said. Well, I guess if they refuse, I don't know why they would refuse. I said they can lower their mask.
Right.
So we'll just make it a rule that they have no mask on?
I've advised all of my witnesses to remove their mask once they start testifying.
Good.
Well, and I'm the closest one, and I'll live with it, so,
What do you have?
okay.
56. I don't have any numbers.
I only have 56, 22, U.S. Army plus 22 is instruction report, which you can...
Yeah.
Okay, yeah, we're good with 56 also.
So, Ms. Zucco?
Yes.
So on the record, the prosecutor and defense have agreed that the court will try two more possibilities in this order. First choice will be 54, second choice will be 56. Also, if it needs to go on the record, pursuant to the request of both parties, no witness will wear a mask when they're on the witness stand. And I'll let the jury know so they don't somehow think that the witness is breaking some rules. And I am the closest one. Yes.
I think they're fine with it.
Thanks. Okay, so I'll be on the phone. Thank you.
Please rise.
I'm sorry, what was this?
Discuss.
We didn't start testimony.
Well, that has nothing to do with this testimony. You're not going to testify. You're going to testify, and I'm waiting for you to not testify. But it's up to you. I mean,
well, that's the problem of me turning it on, is my hearing is such that it doesn't matter if anyone knows it's on or not. I was requested, and it was a valid request. People are allowed to interrupt me, and the clerk knows this for sure when I'm messing up. I will repeat for the audio recording link that it'll be Mr. 56, and he has not read anything, he didn't do any research. He was willing to come back in. I thanked him a great deal. He will be here at 8:30. The court will read to him the preliminary instructions. That takes care of that. We need to figure out the best way to do opening statements. So I'd like to talk to the IT person to see if we can get just that recording. What if we could also get a recording of the 911, or just play it over again for all the jurors, or just play it for him? We could play it for him probably, but would Ms. Zucco, well, I'm kind of thinking out loud, this is new to all of us. I'd like to get an audio recording of opening statements for sure, and just play that. Do either counsel any objection to that sufficing for 56 hearing the opening statements?
I have no objection.
Okay. As far as the 911 recording, it's short, probably we should just play it just for him. Any objection to doing that?
No objection.
And then we bring it, then he's up to speed. And we bring him in and we get our first live witness on the witness stand. So I need to talk to IT. I might as well have y'all hang out here some more so I can report back to you that yes, we can get that recording, as opposed to trying to get a transcript of opening statements, which might be difficult. Also, I think we should continue on the plan of getting Mr. Kimminau's training done.
Yeah, if you can get them over here earlier by chance, that'd be great.
That's what I'd like to do, and I'd like to make productive use of everyone's time. And maybe we can get that done, and she can test the Zoom and train me on Zoom so that that is done. Ms. Zucco, looks like you have something to say?
I just want to make my record on the process of what happened.
You may do so, and I'll tell you if I agree or not with it.
Okay. Before any testimony was taken, juror number 7 asked to approach. It was stated that he recognized the defendant. He had information about the defendant that was not going to be good for the defendant. So there was a defense motion to strike him. He was stricken by stipulation because no evidence had been taken yet. The parties agreed, and the defendant, with consultation of counsel, agreed that he could be replaced with one of these few listed jurors, one of whom was juror number 56, and that the defendant is stipulating that juror 56 is a substitute replacement, but that we also agree that if possible, he will be an alternate so that this does not become an appeal of election.
And I'll just add that juror number 7 stated he was 99% sure he recognized Mr. Wilson from some prior adverse dealings. I asked him to rate it, and that number 56, I understand the agreement is, if numbers allow, will be an alternate.
Yes.
Okay, Mr. Kimminau, would you want to correct any of that or disagree with any of that?
Neither.
Mr. Wilson, can we ask him?
Well, I'm not going to ask Mr. Wilson, I don't think that's necessary. I will put on the record, I think this was clear, we went off the record and I could view and hear Mr. Wilson and Mr. Kimminau going back and forth about what numbers, and they would put out a number, and Ms. Zucco would maybe disagree or agree, but that Mr. Wilson was actively involved in that, and
Okay.
I think that's sufficient.
And then now would be the time if he had an objection to it?
Anybody wants to object or complain, they can so state. I'll pause for a moment. And I hear none. Why don't y'all continue to stick around, and I'll pop back in when I have the information about the, playing the opening statement, if we can get just that part. And this just, off the record for a moment, what if I need a transcript? Is that something the court reporter can do this evening of the opening?
Just the opening?
Just yes, the openings. I'm gonna read the preliminary
Well,
instructions.
there's only one, because he waived.
Well, he didn't waive, he deferred. Thanks for reminding me of that.
Sorry.
So,
Yeah, I would want to, I would prefer to send it in PDF format, because I'm supposed to be leaving early in the morning after going to the dentist to go camping.
as long as I have it, you can enjoy your camping trip, but that's doable before you go in camping? Okay, so I'll try to get the audio so you can pack tonight. All right. Is that better for you to have the audio?
I would rather you use the audio.
We'll try that first then.
If you need to do it, I
Okay.
would do it.
Okay, so back on the record, the court was consulting the court reporter about the feasibility of the transcript. She reminded me that only the state gave theirs, defense reserve, so it's gonna be shorter than, it'll be short. She'll get it done if necessary, but I think all prefer the audio recording. So I will make some more phone calls, and, the corporal may be excused if he wants to leave. If he wants to stick around, that's fine too, of course, but I haven't excused the attorneys yet. And Mr. Kimminau will be staying for a while, we hope, if I can get the IT person up here. All right, thank you. I'll get back to you shortly.
Thank you.
The audio part of the Ms. Zucco's opening statement. By the way, attorneys and Mr. Wilson are present. She'll be up shortly. She gets that done, and she'll then work on the IT issue with defense counsel, and that means I'm getting ready to excuse y'all because we don't need anybody in here other than Mr. Kimminau and my IT person when she gets up here. And then I need y'all back at 8:30, like I said, and I think we have a reasonable plan given the circumstances. Ms. Zucco, before I send y'all home, anything very short and last?
No, I don't have anything else.
Okay, Ms. Kimminau?
Nope, no, Your Honor.
All right, thank you, everyone. And so, Mr. Wilson may be excused, and I'm just with her short. Right.
I couldn't do that.